I want to now turn it over to our co-hosts from GRS Community Management. This is Megan Kelly. Megan, take it away, my friend.
Thank you, Jeff, and thank you for having us this morning and the opportunity to co-host with you guys. For those of you that don't know, GRS, we're a property management company specializing in condo and HOA associations. Our corporate office is located here in Palm Beach County and Lake Worth, but we do manage properties all up and down the East Coast and West Coast of Florida, specializing in Broward, Palm Beach County, and Martin County. So, been doing service since 1989. So I know after this, our information will be shared. If there's anything we can do to help your community or answer anything, we are here. So please don't hesitate to reach out to us. Thank you, Jeff. I'll turn it back over to you.
Thank you, Megan. Well said. And again, thank you for having us. Folks, if you're happy with your management companies, great, do nothing. But hey, if you're out looking and you need to explore your options, give GRS a try, give them an opportunity to pitch you there. So I want to now turn it over to one of the few board certified specialists in condominium and plan development law in the entire state. There aren't many. We have one today from our Palm Beach Gardens office. This is Peter Mollengarden. Peter, take it away, my man.
Thank you, Jeff. And good morning, everyone, and welcome to the Homeowners Association Board Member Certification course. As Jeff mentioned, there I am. I'm a Florida Bar Board Certified Condominium and Plan Unit Development Specialist. Okay, our firm has, I think, 8 or 9 that are Florida Bar Board Certified. Personally, I've been practicing in community association law since 1984. So I've been doing it a pretty long time, going to my 42nd year. I have worked both sides of the street, so to speak. I have worked for developers drafting condominium and HOA documents. That was mostly done actually in up in Maryland and Washington, D.C. For several years. But for most of my career, the vast bulk of it, I've been representing associations in Florida, mostly in South Florida. And our firm, this is what we do. I would say 99% of our practice is representing associations throughout the state of Florida. I believe we have over 3,000 associations. Don't quote me on that. That number that could be up low, but that's what our firm does. And I want to welcome everyone. As Jeff mentioned, this is a homeowner association board member certification course, not for condominiums. So we'll get off that picture of me. So why are we here? Well, we're here because my mouse doesn't want to work.
Click the mouse button one more time, and I think everything should appear.
There we go.
Yeah.
Okay. So why are we here? Within 90 days after being elected or appointed to the board of a HOA, the newly elected or appointed directors must what? Well, they must complete the educational curriculum administered by an education provider, someone like myself, approved by the Department of Business and Professional Regulation. That's what we're doing this morning. This certification that you'll receive after you sit through the course today is valid for up to 4 years. Okay. A director must also complete the education specific to a newly elected or appointed director at least every 4 years. So if you're on the board continuously, you still have to do it again. If you go off the board and come back on, you also have to do it again. And what does our training cover? It covers many different topics, including financial literacy and transparency, record keeping, levying of fines, and notice and meeting requirements. Now, what happens if you don't complete your educational certification requirement? Well, then you're suspended from the board until you do comply with it. During that time, the board can temporarily fill the vacancy until the board member has completed their certification requirement. The association must maintain or retain each director's certification, which you're going to receive. Jeff will send those to you for inspection by the members for 5 years after the director's election. So even if you're on the board for 2 days, the certification is kept for 5 years. However, if the association does not have the certification on file, that does not affect the validity of any board action. Now, in addition to taking the 4-hour course, okay, you have to do continuing education as well. So if you're in an association or you are the director of an association that has fewer than 2,500 lots or parcels, then you have to do at least 4 hours of continuing education every year. So in addition to the 4-hour course today, or the credit today, you have to do 4 hours of continuing education every year. Now, if you're in a very large association that has 2,500 lots, parcels, or more, then it's 8 hours of education every year. Okay, Chapter 720. Chapter 720, as Jeff mentioned, that's the Florida Homeowners Association Act that pretty much that governs the operation of HOAs in Florida. So, difference between HOAs and condos. Okay, the main difference, by the way, is condominiums, you're buying or you're owning airspace. Okay, so they're vertical, not always, but usually they're vertical, high rise, mid rise, whatever, because you can't own airspace without having it be a condominium. HOAs typically, not always, okay, but between HOAs and condos, obviously you're owning the lot and the home and the ground beneath that. You're not owning just the airspace. HOAs come under common law. You have to have a condominium statute to have a condominium, because again, you have to create that manner statutorily of owning literally airspace rather than the dirt, which goes back to the beginning of time. In an HOA, the common areas are owned by the association. In a condominium, they're common elements, and common elements are owned by all the owners and shares. So those are the main differences between an HOA and a condo. Obviously, it's a very thumbnail sketch, but that's generally the difference. Okay. What version of Chapter 720 will apply to your association? Generally, it's the law in effect at the time that the Declaration of Covenants, Conditions, and Restrictions. It has other names, but that's generally what it's called typically. When that's recorded, it's a law in effect at that time. Okay. What about amendments to the law that happen after that? Okay. In Florida, you cannot retroactively apply a substantive law to an existing valid contract. You can't affect the rights created by that contract. And that's actually in the Florida Constitution. Well, that also applies to HOAs and to condos too, but to HOAs. So substantive laws do not apply retroactively. Procedural laws typically do. Procedural laws such as quorum requirements, meeting notice requirements, those kind of things. More substantive things do not apply retroactively unless, like the third bullet point there says, your declaration is subjected to Chapter 720 as amended from time to time. They call it Kaufman language because that derives from a case many years ago, Kaufman versus Shear, which was a condominium case dealing with rec leases, and I won't go into detail on that. But basically, the gist of that case was, if a declaration says that the property has been subjected to Chapter 720 as amended from time to time, that does mean then that future substantive changes of the law will apply to that to those set of documents. Now, this gets kind of complicated. I'm making it simple for our presentation today. If there's any question about this as to what law applies or how does it apply, this is something you really got to run by your association attorney, because it is a constitutional law question. So it's not easy to always ascertain which laws are substantive, which laws are procedural, and whether or not they apply retroactively. Now, as I mentioned before, procedural laws generally mean the means and method for the application and enforcement of existing duties and rights. Okay, and substantive laws or substantive statutes prescribe legal duties and rights, and once those duties are vested, then you can't apply them retroactively. And again, this is something I've touched on it very briefly. If you have any issues when new laws are adopted, how they affect your community, I definitely encourage you to run that through your association counsel to give you an opinion about what he or she may think on that matter. Now, what about conflicts? Conflicts in statutes, that is. As I mentioned, Chapter 720 governs homeowner association, but almost every homeowner association that's created, the ones that I've seen, is created under Chapter 617, which is the Florida Corporation Not-for-Profit Act. And that does apply because you are a corporation, you are operating a corporation. And in the event of a conflict, though, between Chapter 617 and Chapter 720, Chapter 720 will control. Similarly, for condominiums, they're created under Chapter 718. So Chapter 718 will control an imminent conflict. But sometimes sometimes Chapter 720 won't address an issue. And then you do have to look to Chapter 617 to see if it addresses that issue. And therefore that would control, because in that case, there wouldn't be a conflict because it's a matter that Chapter 720 does not address. Again, that's a case-by-case basis. There are also conflicts between your documents. Okay, your documents generally are your declaration of covenants, your articles of incorporation. By the way, the articles are the document that creates the corporation, and then the bylaws. And the bylaws is a document that typically has the procedures for the operation of the corporation. By the way, the term bylaws gets thrown around very loosely by my clients and by the public in general to refer to all your documents as the bylaws. And that's actually incorrect. Okay, the bylaws are a specific document with the procedural things like meeting notice requirements and how many people serve on the board and things like that. But the declaration is the document of highest authority because we have this expression, a little dabble do ya. We got a picture from a Brill Cream ad from 1953 when Jeff Solomon was around. And a little dabble do ya. Basically, this is the hierarchy of your documents in case there is a conflict. Declaration, articles, and bylaws. So the declaration, a document of highest authority. Next is the articles, and next is the bylaws in terms of if there's a conflict, which controls. And sometimes there are conflicts. Like, for example, frequently I've seen conflicts between the articles and the bylaws regarding how many board members or who's eligible to serve on the board. And in that case, the articles would control in the event of a conflict with the bylaws. One document that's not on here, but I'll mention it because it's not a recorded document typically, is the rules and regulations. That's the fourth, and it is the fourth in the order of which one has a control over the other. Okay, and the rules come last. However, the rules are still enforceable if they're properly adopted and are clear. So it's not that they're unenforceable, but they're the caboose on the chain of hierarchy with your documents. Now we're going to go into membership meetings under Chapter 720, specifically Section 723.06. So every year you're required to hold a meeting of your members, the annual meeting, okay, at the time, date, and place that's specified or in accordance with your bylaws. The election of directors must be held at or in conjunction with your annual meeting, unless your documents provide otherwise, which is pretty rare, okay? And there's also special member meetings, okay? Special member meetings are those meetings that may be called either by the board or by the membership, by a petition. If the members are petitioning one, okay, then it's at least 10% of the voting interest asking for that, or unless a different percentage is set forth in your documents, and usually that would be in the bylaws, again, because that is the procedural document. So an annual meeting every year, okay, for your election. You may or may not have a special members meeting. That depends on your community, quite frankly. And many communities only have one membership meeting a year, which is the annual meeting. Whether or not you have a special member meeting depends upon if there's issues that you want that the owners need to address or the members need to address for some reason. Agenda. Unless your documents require otherwise, statutorily, the notice of an annual meeting does not need to include a description of the purpose for which it's called. But quite frankly, I strongly urge you to include the agenda on your annual meeting notices as well. A special member meeting, okay, must include a description of the purpose or purposes for which the meeting is called, again, typically set forth in the agenda. And the business to be conducted at a special meeting is limited to those purposes which are described in the notice. What does a notice have to say? Well, it's pretty straightforward. They must have the date, time, and location of your meeting. If your bylaws, for some reason, do not provide a procedure for giving notice to the members for a membership or owner meeting, then you must mail, deliver, or electronically transmit notice of the meeting to all the owners at least 14 days before the meeting. And quite frankly, I would suggest even if your bylaws have a shorter period of time, I would stick to the 14 days. Now, evidence of compliance with that notice requirement must be made by an affidavit executed by the person providing the notice, which must be kept with your official records, the official records of the association. Where does that notice go? Well, it must be addressed or delivered to the address identified as the owner's mailing address in the official records of the association, or electronically transmitted if the owner has consented in writing to receiving notice by electronic transmission. What's electronic transmission? Email or facsimile. But the owner has to agree in writing to receive their notices of meetings via electronic transmission. And they can revoke that consent as well. But as long as that consent is valid and is in effect, then you can email or fax the notices, if anyone still has fax machines, to the owner. Now, as I mentioned before, you can provide notice of any meeting by electronic transmission, which I said is email or fax, to any member who has consented in writing to receive it in that manner. The email address and the fax numbers, okay, provided by members to receive notice by electronic transmission must be removed from the association's records when that owner or that member, same thing, revokes consent to receive notice in that manner. However, the association is not liable for an erroneous disclosure of an email address or the fax number for receiving electronic transmission of their notice. You cannot use electronic transmission for notice of a meeting, which is called either in whole or in part for the recall of a director. So you can't use email or fax notice of a meeting of the members if they're seeking to recall a director or more than one director. More notice requirements. Broadcast notice. In addition to sending notice to the members, the association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and agenda on a closed circuit cable TV system serving the community, serving the association. That notice and agenda must be broadcast in a manner and for a sufficient amount of time so as to allow sufficient continuous length of time to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda. What is an average reading? Or what is an average reader? I have no idea, but you get the idea. Website posting. By January 1st, 2025, and that was this past year, an association that has 100 or more lots, they call them parcels in the statute, but if you have more than 100 or more lots or parcels, then you must post a notice and the agenda for every meeting of the membership at least 14 days before the meeting. Okay, that's on a website. Okay, you have to post that on a website for those, because now you have to have a website for the 100 or more lot communities. The notice must be posted in plain view on the home page of the website or your app, or on a separate subpage of the website labeled notices, which is conspicuously visible and linked from the home page of the website or the app. The association must also post on its website or app any document or documents to be considered and voted on by the members during the meeting, or any document listed on the meeting agenda, and that has to be posted at least 7 days before the meeting at which that information will be considered by the membership. Owners have a right, as I'm sure most of you know, or all of you know, but owners have a right to attend all meetings and to speak at any meeting with regard to all items that are open for discussion and all items that are on the agenda. And notwithstanding anything to the contrary in your documents, for a membership meeting, you have to provide the members a right to speak for at least 3 minutes on each agenda item or each item that's brought up for discussion. Now, you may adopt reasonable written rules governing the frequency, duration, and other manner of owner statements, which rules must be consistent with the above requirements. And I would suggest you do adopt those rules. They are useful in controlling a meeting and handling a meeting in an efficient manner. Now, membership meetings must be held at a location accessible to a physically handicapped person or persons if requested by a physically handicapped person who has a right to attend the meeting. So if one of your owners who is disabled or handicapped requires or requests that your meeting be held in a location which is accessible, then you must do so. Finally, any owner may either audio or video record membership meetings. You can adopt reasonable rules regarding those tapings. This was more actually back in the day when people would set up lights and had big old cameras. I was at several meetings like that. Now, with everyone using their phone, not so necessary, except one rule that I would suggest is that they have to stay in one place, can't be moving around the room, and can't be sticking their phone, like it's happened to me before, in the face of whoever's speaking. So I think it's reasonable to say that you have to stay in one location while you're video or audio recording and not be moving about the room and not be disturbing the business that's occurring. Quorums and decisions. Okay, quorum, what do you need to actually hold a meeting as far as attendance? Unless a lower, is provided in the bylaws, 30% of the total voting interest of an association constitutes a quorum at a members' meeting. By the way, this is not for condominium associations. They do not have this requirement, or do not have this in their statute. Many documents, especially the older ones, okay, say that a quorum at a membership meeting is a majority of the owners at the meeting in person or by proxy. But pursuant to the statute, it's actually 30% or less if your documents have a lower number. Who makes the decision, or what's the vote required? Well, again, unless otherwise required by statute or your governing documents, decisions that require a vote of the members must be made by the concurrence of at least a majority of the voting interest present in person by proxy at a meeting at which a quorum has been attained. So basically, a majority of a quorum means that vote will vary depending on how many people are represented, how many owners are represented at that meeting in person or by proxy, and that would depend upon the vote required. But you have to check your documents, because oftentimes your documents will have a different voting requirement for whatever you might be voting on, whether that's an amendment to your declaration, amendment to your articles, or some other owner vote. You got to check what is the vote required under your documents, and don't simply rely on majority of a quorum. About proxies, okay? Huge difference here, by the way, between condos and HOAs. I know this is not a condo course, but I'm going to make, as we go through this, raise some distinctions, because sometimes people get confused because they hear so much about condo law and they think that applies to HOAs as well. Okay, unless otherwise provided, okay, in section 723.085 or in the governing documents, members have a right to vote in person or by proxy. Now, again, unless your documents somehow limit that, every owner has a right at a membership meeting, it's not board meeting, by the way, but a membership meeting, to vote in person or by proxy. In order to be valid, a proxy must be dated. It must be signed. It must be signed, dated, and include the date, time, and place of the meeting for which it was given. And number 3, must be signed, as I already mentioned. It's only effective for the specific meeting for which it was given and any lawful adjournments of that meeting. However, a proxy automatically expires 90 days after the date of the meeting for which it is given. Now, you can use this 90-day period, by the way, as a mechanism to get more votes. So let's say you're voting on an amendment to your declaration, okay? You have the meeting, you count up the proxies in your head before time, which is okay, and you're pretty sure you're not going to have enough votes to pass that amendment. Well, at the meeting, okay, you can ask for a motion to adjourn and continue, not adjourn finally, but continue the meeting to a date and time specified, date, time, location specified, and then you can reconvene the meeting, okay? And those proxies which have been submitted are good for that reconvened meeting, because you adjourned it. You didn't finally adjourn it, you adjourned it to be reconvened. So that's a way to gather more votes, potentially solicit more proxies in that interim period. All right. Proxies are also revocable at any time by the person who executed. So if I give my proxy to Joe Smith or Mary Lou, okay, and I say, you know what, I'm going to revoke it, I can revoke that proxy in writing and take away their authority to vote for me. Any proxy holder may appoint in writing a substitute proxy to act in his place if the original proxy provides such right. So typically a proxy will have a substitution power in there, but you have to look for it. So if my proxy holder cannot attend the meeting, something comes up, I give my proxy to Joe Smith, Joe can't make it to the meeting. If there's a substitution power in there, then Joe can substitute someone else to be my proxy holder in his place. A copy of an original proxy can be used if it's a complete reproduction. So the proxies don't have to be originals. They can be copies, they can be emailed, but they do have to meet all those criteria of being signed and dated by the person who is, by the owner who was the proxy giver in that sense, the owner who is giving the proxy. General versus limited. Huge difference here with condos and HOAs. I'm just going to mention quickly, in a condominium, for substantive issues, whatever that might be, voting on amendments in a condo, voting on an alteration issue, voting on whatever, they can only use limited proxies in which the proxy holder is basically not using their judgment, and the owner is telling them on the face of the proxy, indicating how their vote must be cast. However, there is no such limitation for homeowner associations. You can use a general proxy, okay, in which you're granting general powers to your proxy holder to vote any way he or she wants on your behalf, unless your documents provide otherwise. Now, some documents and HOAs do say that only limited proxies can be used for voting on substantive issues. So you have to check your documents to see. Again, condos, they don't have that choice. HOAs, depends what your documents say. But you can use either to create a quorum, to establish a quorum. Electronic voting. By the way, electronic voting here means online voting, not email voting. It means online voting with an internet-based online system. So if your community wants to establish or allow, okay, online electronic voting, then the board must adopt a resolution, which is adopted at a board meeting, for which notice has been given at least 14 days in advance by mail delivery or electronic transmission, and that notice must also be posted in the community. So you have to send a notice out of that board meeting and post it 14 days in advance. That resolution must provide that the members will receive notice of the opportunity to vote through an online system. It must also establish reasonable procedures and deadlines for members to consent electronically or in writing to online voting. It must establish reasonable procedures and deadlines to opt out, so owners can opt out of voting online and go back to what I would call the more traditional or old-fashioned way of voting. The association may conduct membership voting through the online voting system if a member consents electronically or in writing to online voting. And that's valid until the owner decides to opt out, if he or she does, of online voting. An owner voting electronically is also counted as being in attendance at a meeting for purposes of determining a quorum. If you have an online voting system, the association must provide every owner with a method to authenticate that owner's identity, a method that is consistent with the association's election procedures and bylaws, a method to confirm at least 14 days before a voting deadline that the owner's electronic device can communicate successfully with the online voting system. The association must use an online voting system that is able to, so if you're going to have a system, online voting, your system must be able to authenticate the owner's identity, authenticate the validity of each electronic vote to ensure the vote is not altered in transit, transmit a receipt to every owner who has cast a vote online. And if you do have secret balloting for elections, and not all HOAs do, condos they must, not in HOAs, but the system must be able to permanently separate any authentication or identifying information from the electronic election ballot, rendering it impossible to tie an election ballot to any particular owner if the bylaws provide for secret balloting for the election of directors. And again, that's a case-by-case basis for HOAs. For condos, it's for every association. For HOAs, it depends what your bylaws say. And the system must be able to store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, there are several companies out there that sell the electronic online voting software. So generally, when you buy the software or when you hire one of these companies, their system should be able to meet, or better be able to meet, all of these criteria and requirements. Speaking of elections, we're going to talk about that now. Now, a vacancy on the board that is caused by the expiration of a director's term must be filled by election, as opposed to a vacancy caused by the death of a director or the resignation of a director or something like that. But when the term expires, then that director, that seat that is up for election, typically at the annual meeting. As we mentioned, must be held at or in conjunction with the annual meeting unless your documents provide otherwise. Now, the third bullet point is really important. Elections must be conducted in accordance with the procedures set forth in the governing documents. I'm going to make another condo distinction here. In condominium associations, the election process is really, it's governed completely by statute and by the Florida Administrative Code of Regulations. The bylaws, for the most part, are not applicable to a condominium election. It's the opposite with HOAs. In HOAs, the statute directly states that the election of directors must be conducted in accordance with the association's governing documents. Typically, that would be the bylaws, okay, and the articles of incorporation. So don't just do or practice your election like a condominium election because I don't know, your manager's heard so much about it. If you've heard so much about it and you like that method, you like that system, you can't do that. You must follow the procedure that your documents provide in an HOA for the election. Unless otherwise provided in your documents, a quorum of the members must be established in order to conduct an election and any other business of the association at the annual meeting. Again, sometimes in HOA documents, they will parrot or copy the Condominium Act, and have different quorum requirements for elections as opposed for other business. Okay, but unless if your documents don't do that, then you need a typical quorum for an election as you would have for any other business to be conducted. Unless otherwise provided in your documents, directors are elected by a plurality of the votes cast. In other words, who gets the most votes? You don't have to get a majority of all the owners voting for you, but it's the plurality, which means you received a majority, or you received not a majority, you received the most votes or enough votes to be elected to the board. All right, who's eligible to serve on the board? Under Chapter 720, all members of the association are eligible to serve on a board unless they've been disqualified for certain reasons, and we'll talk about that in a few minutes. For example, a person who is delinquent in the payment of any monetary obligation to the association on the day, okay, that he or she could last nominate themselves or be nominated for the board cannot seek election to the board, and his or her name cannot be listed on the ballot. So this would depend upon your nomination process pursuant to your documents. If you have a nomination process in your documents where you do early nominations, in other words, you have a deadline to nominate yourself so many days before the meeting, then you can't be delinquent as of that day. If you have a more traditional, let's say, or old-fashioned system where people nominate themselves from the floor at the meeting, okay, then that's the last day, obviously, that you can nominate yourself. So you can't be delinquent on that day. So this depends upon your documents in terms of what is that last day that you can nominate yourself. Now, if you've been convicted of a felony in Florida or in a U.S. district or territorial court or in another jurisdiction, i.e. another state, which would be considered a felony if committed in Florida, then that person is not eligible to serve on the board until their civil rights have been restored for at least 5 years as of the date on which they're seeking election to the board. A person who has pending criminal charges, pending, not convicted, but pending. A person who has pending criminal charges for forgery of a ballot, envelope, or a voting certificate used in an election, or felony theft or embezzlement of association funds or property, or tampering with physical evidence, such as the destruction of or the refusal to allow timely inspection of an official record in furtherance of a crime, or obstruction of justice. So if anyone who has been even just formally charged or indicted or arrested for any of these items, they're not eligible to serve. Nominations. A member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. So if your documents provide for nominations from the floor, or don't, actually it's better to say, if your documents don't preclude or prohibit nominations from the floor, then anyone can nominate themselves for the board at that meeting. By the way, nominations do not have to be seconded, okay? So you can nominate yourself. However, if your election process set forth in typically your bylaws allows or provides that candidates be nominated in advance of the meeting, the association is not required to allow nominations at the meeting unless the documents say so. So if your association has in their bylaws a condominium style election where there is a pre-nomination process where you have to put yourself into nomination in writing a certain amount of days before the election, and there's no nominations from the floor, then there are no nominations from the floor. Otherwise, there are. Distinction between here and condominiums. In condominium associations, there are no nominations for the board from the floor. All the nominations by statute must be done in advance in a certain time period. So again, here for an HOA, it depends upon what your documents say in terms of what is the nomination process and whether or not there will be nominations from the floor. Election day, election by acclamation. What does that mean? An election is not required unless more candidates are nominated and vacancies exist. So if you have a 5-person board, let's say, and all 5 are up for election, and you have 5 or fewer candidates nominated pursuant to the nomination process, then that's an acclamation. Okay. If an election is not required because there are either an equal or fewer qualified candidates, then vacancies exist. And if nominations from the floor are not required, then they're on the board and you don't need a quorum. All right. So if there's no nominations from the floor under your documents, okay, and you have the same or fewer number of candidates who have pre-nominated themselves as there are vacancies to be filled, then they're automatically on the board and you do not need a quorum. It's one of the few instances where you do not need a quorum at your membership meeting. What about balloting? As I mentioned before, unless your documents provide otherwise, and you have to check, members have the right to vote in person or by proxy. Another distinction, in condominiums, you cannot vote in elections by proxy. It's statutorily prohibited. In HOAs, it depends upon what your documents say. So in an HOA, members have the right to vote in person or by proxy in an election unless otherwise provided by your governing documents. In addition, if your governing documents permit voting, absentee voting by secret ballot, right? Again, kind of akin to a condo style, then the ballot must be placed in an inner envelope with no identifying markups or markings and mailed or delivered to the association in an outer envelope, which has the name of the member, the lot or parcel for which that ballot is being cast, and the owner must sign that outer envelope where indicated. All ballots and proxies, assuming proxies are permitted, are tabulated on the day of the annual meeting. If more than one ballot is submitted for a lot or a parcel, then the ballots for that parcel are discounted and don't count or disqualified. And any vote by ballot received after the closing of the ballot is also not considered. And unless your bylaws provide otherwise, directors serve a 1-year term. Now, you may have a board of staggered terms where you have, let's say, five directors, and every other year you elect either 3 or 2 because they're serving 2-year terms. So you can have more than a 1-year term, but it must be pursuant to your documents. Otherwise, it's a 1-year term. How about it when to challenge that election? Well, the time limit to challenge an election is pretty short, okay? It must be commenced within 60 days after the night or after the election results are disclosed or announced at the election meeting. So 60-day window is pretty short. What about the venue, or where can these election challenges be brought? Well, an election dispute between an owner, member, and an association must be submitted to binding arbitration with the Florida Division of Condominiums, Timeshares, and Mobile Homes. This is one of the few instances where the division actually has jurisdiction over an HOA matter, even though typically they're for condos, but there are some instances where the division has jurisdiction over HOAs, and election disputes is one of them, okay? So you either have to submit your dispute, or a dispute must be submitted for arbitration with the division, or you can file with a court of competent jurisdiction, which typically will be the circuit court of the county in which the community is located in. Election disputes that are submitted to binding arbitration with the division are conducted in a manner provided by Section 718.1255, and again, that's in the Condominium Act, and the procedure rules adopted by the division. What about officers? Okay, a very important distinction. I'm sure all of you out there know this, but generally, officers are appointed by the board immediately following the election of directors at the organizational meeting of the board. By the way, that board meeting, the organizational meeting, that must be noticed. Okay, 48-hour posted notice. It is a board meeting. Now, directors cannot vote by proxy or secret ballot at a board meeting, except the only exception is secret ballots may be used in the election of officers. So 99.9% of the time, the officers, president, vice president, secretary, treasurer, they're elected by the board. Okay, do they have to be board members? Depends on your documents. Okay. And there's no prohibition against changing officers midterm, generally speaking, under every set of bylaws that I've ever seen, actually. Although the officers are elected for, let's say, a 1-year term, ostensibly for a 1-year term, they actually serve at the pleasure, maybe a better word is displeasure, of the board. So the board can, take a president or a vice president out of office. They can't take them off the board. Important distinction. The board cannot recall or vote off someone from the board, but they can change officers. So if the board doesn't like the job or the mayor or the president is running this, not running the association, but is performing his or her duties, they can change presidents, change vice presidents, change treasurer, but those people are, if they're board members, remain board members. Fraudulent election voting activities, and this would never happen to anyone listening, right? I hope not. But a person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. So what are those things? Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of voting activities. Perpetrating or attempting to perpetrate or aiding in the perpetration, a lot of perpetrates there, of fraud in connection with a vote cast or to be cast or attempted to be cast, preventing a member from voting or preventing a member from voting as he or she wants or intends by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate of the member, menacing, threatening, or using bribery or any other corruption to attempt, directly or indirectly, to influence, deceive, or deter a member when the member is voting. And hopefully none of these things will ever apply to anyone who is listening to my voice. Fraudulent election voting activities, there's more. Also, giving or promising, directly or indirectly, anything of value to another member with the intent to buy the vote. Who would buy someone's vote? Of that member or another member, or to corruptly influence that member or another member in casting their vote. However, this does not apply to any food served, which is to be consumed at an election rally or meeting, or to any nominal value, like a, a pin or something like that, or a campaign sticker, that kind of thing. That's not it doesn't rise to that level. Finally, using or threatening to use directly or indirectly force, violence, or intimidation, or any tactic of coercion to intimidate or induce or compel a member to vote or to refrain from voting on an election or in any other matter. So again, these are pretty extreme, and hopefully something you won't have to deal with. Now, as of July 1 of 24, each of these acts is a first-degree misdemeanor, also relating to elections. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, and having knowledge of a fraudulent election activity and giving any aid to the offender with an intent that the offender avoid or escape punishment. All these lovely things that obviously everyone should avoid. Now, what about vacancies I mentioned before that occur not because of the expiration of a term, but typically before the expiration of a term because of a resignation or a death or a disqualification, like an owner, like your documents require that directors must be owners, and the director sells their unit, closes their unit, and is no longer an owner. So let's say there's something where that seat becomes vacant in midterm or any point before the end of the term. Well, unless otherwise provided by your bylaws, so you got to check out your documents, any vacancy occurring before the expiration of a term, not including recall, which is a separate statute, may be filled by an affirmative vote of the majority of the remaining directors, even if the remaining directors are less than a quorum or there's only one left. Let's say you have a 5-member board, 4 people resign. That remaining board member can appoint the replacements. So you don't need a quorum of the board, to appoint if they're the only ones left. In the alternative, the board may hold an election to fill the vacancy, in which case you have to follow the procedures we were just talking about before that are in your documents. Typically, though, in my experience, for all these years, the board will appoint, unless their bylaws says they can't, the board will appoint those replacements. Now, how long do they serve? Well, again, unless otherwise provided by your bylaws, a board member appointed to fill a vacancy created by a resignation or death or otherwise, they serve the unexpired term of the seat being filled. Again, unless your documents provide otherwise. More about the board. Board voting, okay? Officer directors have a fiduciary responsibility to the owners. And that word gets tossed around a lot, fiduciary. Basically, it means trust, okay? You're in a position of trust with respect to your members. You must act reasonably, the reasonable business judgment rule. This is important, okay? You don't always have to be right, although we all strive to be right, whatever right is. But you are allowed to exercise your reasonable business judgment. Now, that means you have to act in good faith, in a reasonable manner, that without fraud or self-dealing or things like that. But generally speaking, the decisions of a board member or the board will not be overturned, assuming they're otherwise legal, okay, as long as the board is exercising their reasonable business judgment, okay? Unless otherwise provided by your documents, the association's powers are exercised and administered by the board. So generally speaking, there's only a few things that owners typically have a right to vote on, election of directors, amendments to documents, maybe some other things pursuant to your documents, like alterations. We'll talk about that later. But generally speaking, the board runs the show. The board runs these. And by the way, it's the board that runs the show, not the president. We'll talk about that. Unless delegated, no board member or no individual board member should be making decisions unilaterally for the board, like the president. Directors may not vote by proxy or by secret ballot. We mentioned that before, except for the election of officers. Okay. And although members can communicate with each other by email, you cannot cast a vote on any matter by email. So you can communicate with each other, but you cannot vote by email. But about notices of board meetings, okay? Similar to the membership meetings, you have to have the date, time, and place of the meeting, and you do have to identify all agenda items. Remember, by membership meetings, it was only agenda items for special meetings, although you should do it for annual as well. But for all board meetings, the notice must identify all agenda items. And the reason for this is pretty clear, okay? That the owners have to be aware of what matters or issues the board's going to be addressing or considering at any board meeting. And therefore, the owner, the member, can then decide whether he or she, if that's an issue that they want to show up and speak about or hear. So all items to be addressed or considered must be set forth on the agenda. Assessments have their own particular thing in the statute. An assessment may not be levied at a board meeting unless the notice of the meeting includes a statement that assessments will be considered and the nature of the assessments, okay? Unless the bylaws provide otherwise, notice of all board meetings must be conspicuously posted in the community at least 48 hours before a meeting, except an emergency, and we're going to talk about emergencies later. 14-day notice. So there are certain board meetings where you need a 14-day notice rather than a 48-hour notice. And unless your bylaws provide otherwise, written notice of any meeting at which a special assessment or the adoption or amendment of a rule regarding the use of a lot or the use of a parcel will be considered. That notice for that board meeting must be mailed, delivered, or electronically transmitted to all owners and posted conspicuously on the property at least 14 days before the meeting at which you're going to consider the special assessment or consider that rule regarding the use of a lot or a parcel. Extremely important, especially with special assessments. If you don't meet this meeting notice requirement to consider the adoption of a special assessment, then the collection of that special assessment will be, quite frankly, in jeopardy, because that is a reason to basically oppose or not to pay an assessment if it wasn't properly adopted, special assessment. Website. We mentioned before, as of January 1 and 25, if you have 100 or more lots or parcels, you have to have a website or an app. Okay. So in addition to other notice methods, the association may adopt by rule a procedure for conspicuously posting the board meeting notice and agenda on the association's website or downloadable mobile app for at least the minimum period of time for which notice is also required to be physically posted. So in essence, though, if you have 100 more lots, you have to post it on your website. If you have less than 100 lots, then you may. In other words, you at your option, you can also post on a website. But if you have 100 more lots, you must. So keep that in mind. Any rule adopted must include a requirement, as far as the rule about posting the notice on the website. Any such rule must include a requirement that the association send electronic notice to members whose email addresses are included in the association's official records in the same manner as required to inform them of a notice of a membership meeting. Such notice must include a hyperlink to the website or app on which the meeting notice is posted. And again, I mentioned this is like the 18th time I've said this, unfortunately. By January 1, 2025, 100 more parcels must have a website or an app and must post notice of any board meeting, the agenda, and any other document for such a meeting no later than the date required for the notice. And that's for membership meetings as well. What about participation? Well, similar to what we talked about before regarding a membership meeting, all meetings of the board must also be open to the members, but there are two exceptions. Okay, there are two exceptions to membership meetings being open to the owners. The first is when the board is meeting with its attorney, okay, with its counsel, with respect to proposed or pending litigation, where the contents of the discussion would otherwise be governed by the attorney-client privilege, okay, and meetings held for the purpose of discussing personnel matters or personnel issues. Members have the right to attend all board meetings and the right to speak at any board meeting with reference to all designated agenda items. The association may adopt, similar to what we mentioned before about membership meetings, reasonable written rules regarding the frequency, duration, and other manner of member statements, including, for example, a sign-up sheet for members wishing to speak. Now, unlike the membership meetings where they must allow a member to speak for at least 3 minutes, okay, there is no statutorily prescribed time limit for members to speak at a board meeting, although quite frankly, it has to be reasonable. I think 3 minutes is reasonable. So, I think as a good rule or general rule of thumb, allowing 3 minutes at a board meeting is, in my view, in my opinion, the right way to go, even though it's not statutorily required. Recording and handicap access. Similar to membership meetings, an owner can audio or videotape board meetings. And again, you can adopt reasonable rules regarding that recording. And similar to what mentioned before, board meetings must be held at a location accessible to a physically handicapped person if it is requested by a physically handicapped person who has a right to attend the meeting. How about paying those board members? I'm sure all of you out there are waiting for those big paychecks to come in now that you're on the board. Well, you may have to wait a while. A director, officer, or committee member may not directly receive any salary or compensation from the association for the performance of duties as a director, officer, or committee, and may not in any other way benefit financially from service on the association, except for the following, and I'm not sure you're really benefiting, but except for the following exceptions: participation by such person in a financial benefit accruing to all or a significant number of the members as a result of actions lawfully taken, reimbursement for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures. So you should have approval procedures for reimbursing directors for expenses. Recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefit of the membership. Any fee or compensation authorized by the governing documents, which quite frankly I have never seen, but it is theoretically possible, or by a vote of majority of the voting interest, voting in person or by proxy at a membership meeting. Don't see that too often either. Or finally, a developer or its representative serving as an officer, director, or committee member of the association. They're going to get paid from the developer for their other developer duties. Kickback, okay? All this is pretty common sense, and hopefully, again, none of this will apply to anyone who's watching or listening. But please note that under Chapter 720, an officer, director, or manager cannot solicit, offer to accept, or accept a kickback. And what is that? A kickback is anything or service of value for which compensation or for which consideration, has not been provided for an officer's, director's, or manager's benefit, or for the benefit of an immediate family member from any person providing or proposing to provide goods or services to the association. I mean, the obvious example is you can't take a bag of cash from the painting company to paint the association's buildings. Obvious one. An officer, director, or manager who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. An officer, director violating this prohibition must also be immediately removed from office by the board, creating a vacancy to be filled according to law until the end of the term of office. However, an officer or director or manager can accept food to be consumed at a business meeting with a value of less than $25 per person, or services or goods received in connection with trade fairs or education programs. When you walk around the trade show and you pick up stuff from people's tables, that's not a kickback. Grounds for immediate removal from the board. So a director or officer charged, again, this is not convicted, charged by information or indictment with any of the following crimes must be removed from office: forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement involving association funds, again, just charged, not convicted, tampering with physical evidence as provided in sections 918.13, destruction of or the refusal to timely allow inspection or copying of an official record in furtherance of a crime, and obstruction of justice as provided by Florida law, chapter 843, and any criminal violation under the HOA Act. Now, what happens in that instance? Someone's charged with a crime, one of those crimes. Well, in that instance, that person's off the board, and then the board must fill the vacancy until the end of the period of the suspension or the end of the director's term, whichever occurs first. So if the charges get dropped, okay, they're no longer under indictment or information, then that person is no longer suspended. So it says if the charges are resolved without a finding of guilt or without acceptance of a plea of guilty, or nolo contendere, which is no contest, the director officer must be reinstated for the remainder of his or her term. If the criminal charge is pending, the person may not be appointed or elected to any position as an officer or director of any association and may not have access to the official records of any association except pursuant to a court order. One that comes up more frequently than all those crimes is a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association is deemed to have abandoned his seat, creating a vacancy to be filled. Now, the difference here is in the other removals, with those criminal charges pending, once the charges are dropped or dismissed, then the person's reinstated. However, if you are more than 90 days delinquent in the payment of any monetary obligation, that includes a fee, a fine, a fee, an assessment, you are permanently abandoned. In other words, you have abandoned your seat. And even if you become current the next day, it's too late. So if you're more than 90 days delinquent, there is no cure, in essence. You're off the board. If you do become current, you can run for the board again, but you're off in terms of that term of office. Conflict of interest disclosures. Okay. Directors and officers, including those who are appointed by a developer, must disclose to the association any activity that may be reasonably construed to be a conflict at least 14 days before voting on an issue or entering into a contract that is a subject of a conflict. So what is a conflict of interest? Well, there's a rebuttable presumption of a conflict exists if any of these following actions occur without prior disclosure to the association. A director officer or a relative of a director officer enters into a contract for goods or services with the association. A director officer or a family member, relative of a director officer, holds an interest in a corporation, an LLC, a partnership, a limited liability partnership, or any other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. So, in other words, can't be hiring your board members to provide services or a company or a corporation or an entity in which that director or family member has a financial interest, basically. Those are conflicts of interest. If you do enter into a contract or other transaction with a director or with a company or entity in which the director is a director or an officer or has a financial interest, then you have to comply with certain requirements. You have to jump through certain hoops, literally, in order to follow through with that transaction. So what are those hoops? The proposed contract with the director must be fully disclosed to the board, and the disclosure entered into the minutes of the board meeting at which that contract will be considered and voted upon. And it must be approved by a vote of 2/3 of the directors present at that meeting. The contract or transaction with the director must be reasonable and fair to the association. And at the next regular or special members meeting, the existence of that contract must be disclosed to the membership. And any member may make a motion at that meeting to cancel that contract. And it can be canceled by a majority vote of the members that are present at that meeting. Again, provided a quorum is obtained. And then if the members vote to cancel that contract, then the association is only liable for the cost of the value of the goods and services provided up to the time of cancellation, and they're not liable, the association is not liable for any cancellation fee, liquid damages, or any other kind of penalty for canceling that contract. Official records, which are also very important. What are the official records? I'm going to kind of read through this quickly. You can also read it yourself in the statute. Copies of any plans and specs, permits, and warranties related to basically the improvements within the common area or other property that you're obligated to maintain. All the governing documents, we mentioned before, declaration, articles, bylaws, and rules. Okay. Doesn't say rule, yeah, it does say rules there. And all the amendments to those documents. You must maintain an adequate copy of the recorded documents to ensure their availability to owners and prospective owners, purchasers. You have to maintain the minutes of all meetings of the board and the membership, a current roster of all the members and their designated mailing addresses and lot identifications, and email address and fax numbers for those members who, again, who have agreed to receive notice in that manner and has provided those email addresses or fax numbers to the association. Insurance policies, all contracts that the association is a party to, all bids received by the association for work. Financial and accounting records, very important, kept according to good accounting practices, accurate. And what are those records? Accurate, itemized, and detailed records of all receipts and all expenditures. A current account and periodic statement of the account for each member, designating the name and address, current address of each member who is obligated to pay assessments, the due date and amount of each assessment, and other charge against the member, the date and amount of each payment, and the balance due. So basically, an account record for every member regarding, their payment to the association. All tax returns, financial statements, and financial reports. Basically, anything dealing with any financial aspect of the community must be maintained as part of the financial records in the official records. A copy of the disclosure summary described in 720-401. That's a Marketable Record Title Act thing. We'll talk about that in a little bit. Ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to any vote by the owners, those records must be kept for at least 1 year after the date of the election or the vote. All affirmative acknowledgments made pursuant to 723-08-303, that's regarding how people are going to be sent their invoices or their statements or their bills for payment. All other written records of an association that are not specifically identified above, that's the catch-all. So basically, any written record, okay, that's related to the operation or the administration of the association is part of your official records. Now, not all of them are accessible to owners, and we're going to talk about the things that are not accessible to owners in this presentation. You have to maintain them for at least 7 years, unless your documents require longer. Bids for work must be maintained for at least 1 year, okay? Effective July 1 of 24, you must adopt written rules governing the method or policy by which the official records are to be maintained, and the time period such records must be retained. And that information must be made available to the owners, again, through the website or the app, assuming you're required to have one. As I mentioned before, certain things are not accessible. So, number one, attorney-client or work product privilege. So anything your attorney sends to you, anything you send to the attorney in writing, that's attorney-client privilege, okay? Work product privilege we'll talk about in a few minutes. Work product privilege relates to litigation that the association is involved in. Any information obtained in connection with the approval of the lease, sale, or other transfer of a parcel. So if your documents have a process for approving purchasers or tenants, okay, and you have an application process, anything you obtain, the application, other information, background information, whatever, regarding the approval or the screening of a tenant or a purchaser or an occupant, those things are privileged and only accessible to the board, not to the other owners. Information obtained in a gated community in connection with guests, visits to owners or residents, that's privileged. Now, Social Security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, and any address other than as provided for association notice requirements, and any other personal identifying information, excluding the person's name, lot designation, mailing address, and property address. So basically, all these things are privileged and not accessible, except as we mentioned before, if I've agreed with the association to receive my meeting notices, board meeting notices, membership meeting notices by electronic transmission, and I provide an email address or a fax number for that, then my email or my fax number will be accessible because that is my official address for receiving association notices. Otherwise, email addresses, phone numbers are not accessible. Fax numbers are not accessible to the other owners. The association is not liable for the disclosure of protected information if the information is included in an official record and is voluntarily provided by an owner and not requested by the association. Other things that are not accessible: personnel records of association or management employees. By the way, that does not include the management contract, either with the management company or with the property manager individually. So the contract itself, that's not a personnel record, so that is accessible. Also, if there's information about in your budget related to like how much the management company is being paid or something like that, that's also not a personal record if it's in the budget or if it's in their contract. Medical records of owners or residents. By the way, medical records, that would include if you are basically been asked to grant an accommodation for a support animal or an assistance animal, and the owner for a support animal is giving you documentation from their doctor or their other licensed health provider, that letter or whatever they're giving you in writing, that's a medical record, not accessible to other owners except to be reviewed by the board when evaluating that request for the accommodation. Any electronic security measures that are used by the association to safeguard data, including passwords. Again, these are all things that owners are not entitled to inspect. The association software and operating system, which allows the manipulation of data, even if the owner owns a copy of the same software used by the association. And again, all affirmative acknowledgements under 72308. Attorney-client privilege, we mentioned a little bit before. Basically, as I mentioned before, anything that the lawyer sends to you, you send to the lawyer, that's privileged. But there's also something called the work product privilege. So if you are engaged in litigation or about to engage in litigation, and the attorney has requested, or either on their own or through the association, to get an engineering report related to that litigation or other expertise report or their expert report, things like that, since that's been prepared by the attorney or at the attorney's express direction, that type of item comes under work product privilege, okay, and is not accessible until the litigation is completed. The correspondence from the lawyer, that remains privileged unless the board votes to waive the privilege. So the attorney cannot waive the privilege. The attorney cannot waive the attorney-client privilege. Only the board can waive that privilege. If it wants to, send out that attorney letter, then they have voluntarily waived the privilege, that opinion letter, or make that letter available to other owners, or to the owners. But again, that is a privilege that the board can waive, but the lawyer cannot. How about a directory? You can print and distribute to the owners a directory containing the name, lot address, and phone number of each owner. However, an owner can opt out or exclude their phone number from the directory by requesting and writing to the association. So if you're going to do a directory, give the owners sufficient reasonable time to exclude themselves or opt out of being in the directory with respect to their phone number. An owner can also provide written consent to the disclosure of other information, contact information, which is otherwise not accessible. So if an owner, for whatever reason, says, yeah, here's my email address, and I allow you to give my email address to anyone who asks for it, okay, then that owner has voluntarily waived the privilege with respect to their email address. Otherwise, unless it's an email address for the meeting notices, owners are not entitled to view the email address of other owners. Providing the rules and covenants to your members, to your owners, okay? Before October 1st of 24, an association is required to provide a physical or a digital copy of the association's rules and covenants, i.e. declaration, and all the amendments to every owner. An association, or remember, an association must provide a physical or digital copy of the rules and regulations and the covenants to every new member. Everyone that's coming in, every buyer, every purchaser, or if you otherwise how you acquire the home, the lot, they are also entitled to copies of the documents. If the rules or covenants are amended, then you must provide every member with an updated copy of the amended rules or covenants. The association may adopt rules establishing standards for the manner of distribution and time frame for providing copies of the updated rules or covenants. You can comply with this requirement by posting a complete copy of the rules and the covenants on your website, on the homepage, and you send notice to each member of his intent to utilize the website for that purpose. You can send that by email to any member who has consented to receive notices by electronic transmission and provide an email address to the association for that purpose, or you mail it to all the other members at the address that they've provided for the official record. So if you're going to provide these documents via website, then you have to basically notify the owners that they're available on the website. What about access to the records? Okay. Unless otherwise provided by law or your documents, they must be made available for inspection and copying by any member of the association within 45 miles of the community or within the county that the community is located, and within 10 business days of receipt of an owner's written request to have access to the records for inspection or copying. To comply with these requirements, you may have a copy of the records available for inspection and copying in the community, make the records available electronically via the internet, and allow the records to be viewed in electronic format on a computer screen and printed upon request. If the request is submitted by certified mail, return receipt requested, from the owner, and access to the official records is not timely completed, then that creates the rebuttable presumption that you have the association has willfully failed to comply with the requirement to provide access to the records. A member who is denied access to the official records is entitled to actual damages, if there are any, or minimum damages for the association's willful failure to comply. The minimum damages are $50 per calendar day, up to 10 days, so $500, beginning on the 11th business day after receiving the owner's written request. As of July 1 of 24, if you receive a subpoena for records from a law enforcement agency, then you must provide a copy of the records or otherwise make the records available for the inspection and copying to that agency within 5 business days after receipt of the subpoena, unless otherwise specified by the agency or the subpoena. An association must also assist a law enforcement agency in its investigation to the extent permissible by law. Official records crime. So there are certain actions that an association or board member can take with respect to the records, which are actually criminal. And again, these are things hopefully that no one who's listening is going or watching will ever be involved with. But anyway, a director or manager who knowingly, willfully, and repeatedly, which is 2 or more times in a 12-month period, fails to provide access to the official records with the intent of causing harm to the association to one or more of its members commits a second-degree misdemeanor. Any person who knowingly and intentionally defaces or destroys accounting records during the period in which the records are required to be maintained, or who knowingly or intentionally fails to create or maintain accounting records that are required to be maintained or created with the intent of causing harm to the association or one or more members commits a first-degree misdemeanor. And finally, actually, I think there's more. Any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime or to assist another person with such avoidance or escape, they commit a third-degree felony. Official record rules. You may adopt, and I would encourage you to adopt, rules, reasonable written rules regarding the frequency, time, location, notice, records to be inspected, and manner of inspection. However, you got to be careful with these rules. You cannot require an owner to show any proper purpose for the inspection. And I hear this all the time from my clients. Oh, Joe Blow or Susie Q, they're harassing us. They just want these records for pure harassment. This isn't fair, blah, 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 blah. they don't have to show you any reason or any purpose for the inspection. And just because that person might be, in your opinion, the worst so-and-so on the face of the earth, okay, doesn't make a difference, okay? Do not let personal feelings or like or dislike come into the play here. You cannot require an owner to show any purpose, proper purpose for any inspection. You can't require an owner to state any reason for the inspection. If they just want the records, they want the records. And don't worry about it. Again, if you think they're getting the records for some nefarious purpose, well, fine, you can think that. But they're entitled to the records, and you must provide access and provide the ability to copy those records or obtain copies of those records. And you cannot limit an owner's right to inspect records to less than 1 8-hour business day per month. So don't give them 10 minutes to look at the records. What about copying and the costs? Well, an owner or their authorized representative, okay, is allowed to use a portable device, and that could be a smartphone, a tablet, a scanner, a portable scanner, or any other technology capable of scanning or taking photographs to make an electronic copy of the record. You cannot charge them for using their device to scan or photograph the records. If you have a photocopy machine available where the records are maintained, let's say the records are maintained at your management company's office and they have a copier there, okay, then you must provide owners with copies on request during the inspection time, during the inspection session, if that entire request is limited to no more than 25 pages. And you can charge up to 25 cents per page for copies made on your photocopier. If the association does not have a photocopier, or the records requested exceed 25 pages in length, then you can have the copy sent out to a copy service, okay? And you can charge the actual cost of the copying as supported by a vendor invoice. So if you're sending out to I won't mention names of copy services, but if you go out to a commercial copy service and it's more than 25 pages, you then can charge the actual cost, but you need that invoice from that service. What about personnel costs? By the way, the personnel cost, this is not in the Condo Act, this is an HOA Act specific provision. The association may charge for the costs required for personnel to retrieve and copy the records if the time spent retrieving and copying exceeds a half an hour and the personnel costs do not exceed $20 per hour. Personal costs may not be charged for record requests that result in copying of 25 or fewer pages. And I mentioned before, you can adopt rules and regulations. If you want to charge these costs, I would put these costs subject to the statutory limits into those rules and regulations. Website, we mentioned that several times. Again, by January 1 of 2025, if you have 100 or more lots, you are required to have a website or downloadable mobile app for posting of the association documents. That website or app must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and only accessible to the owners and employees of the association. Upon written request of an owner, you must provide that owner with a with a username and password, combine those, with a username and password and access to the protected sections, in other words, the sections only available to the owners of the association's website or app, which contains the association's documents. And then you have to post on your website, if you're required to have a website, certain things, such as your governing documents, declaration, articles, bylaws, and amendments, the rules, current rules, a list of all current executory contracts or documents to which the association is a party, or which the association or the owners have an obligation or responsibility, and after bidding for the related materials, equipment, or services, a list of bids received by the association within the past year, the annual budget, and any proposed budget to be considered at the annual meeting. Now, that's a little unusual because budgets are typically considered by the board at a board meeting and not at the annual meeting, but for whatever reason, if you are considering the adoption of a budget at an annual meeting, that proposed budget must be on the website. The financial report and any monthly income or expense statement to be considered at a meeting. That's the annual financial report they're referring to there. The association's current insurance policies and the certification, i.e. what we're doing today, of each director. What else? All contracts or transactions between the association and any director, officer, corporation, firm, association that is not an affiliated HOA or any other entity in which an association director and also a director is also a director or officer and financial interested. In other words, those conflict of interest things. And then the second bullet point kind of dovetails into that. Any contract or document regarding a conflict of interest or possible conflict of interest. Those two are actually, in my view, the same. Notice of any board meeting, the agenda, and any other document required for the board meeting, which must be posted no later than the date required for the notice. So, for example, most board meeting notices are 48-hour notices, but there are some, which I mentioned earlier, that are 14-day notice requirements, special assessments, and rules regarding the use of a parcel. So if it's a 14-day notice requirement, then you got to post the stuff at least 14 days in advance on the website. If it's a 48-hour notice, then it's a 48-hour requirement. Notice of any membership meeting and the agenda for the meeting. So board meetings and membership meeting documents required to be on the website. With respect to membership meetings, has to be posted at least 14 days before the meeting in plain view on the homepage of the website or on a separate subpage labeled notices, which is conspicuously visible and linked from the homepage. You must also post any document to be considered and voted on by the membership at that membership meeting, or any document listed on the agenda of that meeting notice at least 7 days before the meeting at which the document or that information in the document will be considered by the owners. You have to ensure that the information and records which are not allowed, remember we talked about things that are not accessible, well, please do not post that on your website. Okay, so if something is privileged or inaccessible to the owners, then it's not to be posted on the association's website. If protected information or information restricted from being accessible is included in documents that are required to be posted, then you have to redact them. So if for some reason you're required to include some document on the website, but it has information that otherwise is unacceptable, then you have to redact or black out that privileged information from that document. The association or its authorization is not liable for disclosing or protected or restricted information unless the disclosure was made with a knowing or intentional disregard of the protected or restricted nature. So if it's just an inadvertent oops, well, we didn't mean it, oops, then there's no liability. If you knowingly or intentionally posted something that you were not required to, or not permitted to, okay, then that's a problem. So it does have to be a knowing or intentional disregard of the protected nature of the information that was posted. Amending your documents, okay? Now, most documents have amendment procedures and provisions. However, unless otherwise provided in the documents or by law, any governing document may be amended by the affirmative vote of 2/3 of the voting interest. This rarely comes into play, again, because almost every set of documents, declaration, articles of bylaws has an amendment procedure in that document or referred to in another document. Sometimes the declaration will refer to the amendments of articles of bylaws. But if for some reason it doesn't, then it requires a 2/3 vote. Amendments to the articles and bylaws which affect or impose a quorum or voting requirement greater than the general quorum requirement are not required to be approved by that greater quorum or voting requirement then in effect or proposed to be adopted when voting to lower that threshold. Now, very important, the format. This is relatively new. It's been in the condominium law forever, fairly new for HOAs, and that proposed amendments must be formatted to show text, to show that new text or language being added is underlined, okay, and text or language being deleted must be stricken through or crossed out. However, if the change is so extensive that that formatting would make it difficult or hinder the understanding of the amendment, then you can basically print the entire new section without the underlining and cross-throughs, but you have to include the following notation preceding the proposed amendment. It has to say substantial rewording, see governing documents for current text. So if doing the strikeout and the underlining, it makes it very, very difficult to read because it's pretty extensive, then you can just have a nice clean version of the new amendment language, but you have to indicate right before it for the owner to see the governing documents for the current text so they can compare the language changes for themselves. What if you need mortgagee or lender consent? Well, under the Homeowner Association Act, that addresses the process of amending documents when mortgagee consent to an amendment is required. We're not going to go through that with detail, but basically you contact the mortgagees and they have a certain amount of time to respond. If after 60 days there is no response from the lender or from the mortgagee, then the lender is deemed to have consented to the proposed amendment. Check your documents for lender approval requirements. When is it effective? An amendment to a governing document, declaration, articles, bylaws, is effective when recorded in the public records of the county in which the community is located. Within 30 days after recording an amendment to your document, you're required to provide copies of the amendment to the members. However, if a copy of the proposed amendment was provided to members prior to the meeting and it wasn't changed, okay, it wasn't changed, during the meeting, then the association can provide notice to the members that the proposed amendment was adopted and that a copy is available upon request at no charge to the owner. That notice must include the official record book and page number, that's the recording information, of the amendment, of the recorded amendment. However, the failure to timely provide notice of the recording of an amendment does not affect the validity or enforceability of the amendment. This is some, things that you should be aware of with respect to operating the association. There are some government filings that you have to do because you are a corporation, okay? You have to maintain your active corporate status, so you have to file an annual report with the Division of Corporations between January 1st and May 1st of each year, and there's a filing fee for that. And on that annual report, you're going to have certain information, the principal address, the mailing address of the association, the registered agent, very, very important, the registered agent for the association. And I'm not shilling for lawyers here, but I think if possible, I would have the registered agent be your attorney, okay? Because the primary purpose of the registered agent of a corporation is to accept service of process. So when that corporation gets sued, okay, either by whoever, okay, they have to serve the registered agent. Lawsuits are required to be responded to within a certain amount of time. It's usually 20 days. Otherwise, it's a default. If the registered agent is a board member or a manager and they're not really, keen on the importance of what's going on, and that lawsuit gets put in a file or thrown in a drawer or whatever and doesn't get responded to, that's a problem. So again, not that I'm shilling for lawyers here, it's not my job, but registered agent, in my opinion, if you have an attorney, I think he or she or their firm should be the registered agent. Anyway, the other annual filing is your income tax. A not-for-profit corporation under Chapter 617 is not exempt. So you're not-for-profit doesn't mean tax exempt, okay? Assessments are not taxable income. They're called exempt function income, but other revenue is taxable. That could be estoppel fees. It could be, I don't know, if you're renting property, or you're renting something, or you get other kind of fees, other kind of income. Long story short, you have to file an annual tax return. Whether or not you're going to be liable for taxes or not depends upon your situation and what your non-exempt function income is. Okay, but every year you need to do your corporate annual statement, corporate annual report, and your tax return. Meeting minutes. All meetings must have minutes taken. Minutes do not need to be verbatim records. In fact, I would recommend they are not verbatim transcripts. This is not the congressional record, okay? And usually those things will backfire on you and create more problems. So the minutes, what they need to provide for basically is who is in, God, I'm talking about board meetings right now. Who is in attendance? Was there a quorum? Okay. And what motions were made? What is that motion? And what was the vote on that motion? You don't need to have all the comments and all the discussion from the board members or the owners. And I, quite frankly, recommend you don't. Now, owners can record those meetings. So if they want a verbatim transcript from themselves, they can record it and have it. Important, the last bullet point. A vote or abstention from voting on each matter voted upon from each director, for each director, must be recorded in the minutes. So the minutes can't just say the motion passed 4-3 or the motion failed 4-3 or whatever. You have to have every board member's vote and how did he or she vote either yes, no, or abstention for all matters that the directors voted on at that meeting. Material alterations typically is more of a condominium issue, but it is an issue for HOAs too, to a certain degree. So what is a material alteration? Well, there's a famous, not famous, but the seminal case for condominiums is Sterling Village versus Breitenbach, and they came up with this language, the court did, that a material alteration means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. Although this is not a HOA case, this definition of material alterations has pretty much been applied, in our view, my view, to any material alteration matter or issue. Now, Condominium Act, very specific about material alterations and how they're approved. HOA Act, not so much. In fact, there's nothing in the HOA Act regarding the approval process for a material alteration to your common area. So you really got to check your governing documents carefully and see, do they address it in any manner regarding making alterations and improvements to your common area. You also have to look at Chapter 617 for that, because that has corporate powers in there. I would highly recommend or suggest that if you're going to make a material alteration to your common area, clubhouse, tennis courts, roads, whatever it might be, when I say alteration, I mean change, not just repair, that you contact your association counsel, because this can be one, especially in an HOA, at least in a condo, you got a statutory process. So it's a little easier because you know exactly what the votes are. In HOA, you really got to read the tea leaves sometimes and try to figure it out. So you may need counsel assistance in that regard. Again, not shilling for lawyers here, but I'm just trying to point out issues that sometimes they help. All right, rules and regulations. Authority to adopt rules and regulations pertaining to governing documents must be set forth in the governing documents. Be advised that, the board doesn't have the authority to adopt rules and regulations just, by some sort of divine power, okay? You got to look at the documents, declaration, articles, and bylaws to see what do they say about the authority to adopt and amend rules and regulations. Typically, the documents will grant that authority to the board, but many times they'll say that rules and regulations must also be approved by the members or are subject to a veto of the members. So you got to read all your documents carefully. You also have to make sure what is the extent of that rulemaking authority. In other words, does the rulemaking authority extend to the lots and the common area or just the common area? Because that's important too. You can't assume, and I won't say what that word stands for sometimes, but you can't assume that the board has authority to adopt rules and regulations and has the authority to adopt them with respect to the lots and the common area. Look at your documents and determine what is the rulemaking authority and the extent of that authority. As we mentioned before, if there's going to be a rule adopted or amended regarding the use of a parcel or the use of a lot, that's a special type of board meeting, and the notice of that board meeting must be mailed, delivered, or electronically transmitted to all the owners and posted in the community conspicuously at least 14 days in advance. Remember, as we mentioned before, that electronic transmission of notice is only permitted to those owners who have agreed in writing to receive notice in that manner. Okay, what about other rules? Written notice of any meeting at which the board will consider the option of an amendment, the adoption or amendment of a rule, let's say regarding common area, that's a 48-hour posted notice. Okay, so if you're going to do a common area rule, again, assuming the board has that authority, that board meeting doesn't require the 14-day notice. It's when you're adopting a rule regarding the use of a lot or a parcel. The Marketable Record Title Act. This is very important for a community that is approaching its 30th year anniversary from the recording of the declaration. A declaration of covenants begins to automatically expire on a lot-by-lot basis, depending on when that lot was originally conveyed by the developer. Okay, 30 years after the initial recording of the declaration. So that declaration then must be preserved before that 30-year date. As the law was amended fairly recently, at the first board meeting following the annual meeting, not including the organizational meeting, the board is required to consider the desirability of filing a notice to preserve the covenants affecting the community or association from extinguishment under the Marketable Record Title Act, and to authorize and direct the appropriate officer to file a preservation of the covenants. Preservation can be done in certain ways or specific ways for an account, and that is good for or effective for another 30 years. A written notice under 712.06 Florida statutes, a summary notice under section 720.3032, and that's as of October of 2018, an amendment to the declaration which references the recording information of the declaration, again, as of October 1st, 2018. And then if the documents have expired because they were not preserved before that 30-year point, you can undergo a process to revitalize them, but that process requires a vote of the membership. Prior to the 30-year preservation, that's a board action. If they become expired, then the owners have to. Now, these are fairly complex actions. In this one, I'm going to tell you, I don't think you should. You must, in my view, consult with your attorney if your community is approaching that 30-year point to make sure that your covenants are preserved. And if they've been expired, then they have to be revitalized. Because once they're expired, you can't enforce them, as far as collection of assessments or anything else. Emergency powers. Okay, so under emergency conditions, now typically that was what for Florida? Usually hurricanes. But then, a few years ago, as I'm sure we all remember, unless you were under a rock, we had the pandemic and we had the COVID pandemic. So the emergency power statutes were amended post-pandemic to include other things regarding these emergency powers. So unless specifically prohibited by your documents, the board can exercise emergency powers in response to damage or injury caused by or anticipated in connection with an emergency for which a state of emergency is declared in the area encompassed by the association. So here in Florida, the governor, he or she, still here right now, has basically the authority to declare a state of emergency. Sometimes it's limited to a specific location. For example, state of emergency for this county or that county that was hit by hurricane, whatever. Back in the pandemic, it was the entire state was covered by the state of emergency. So it depends upon whether the jurisdiction in which your association is located is under a state of emergency declared by the governor. These emergency powers are only available to the board for a period of time that is reasonably necessary to protect the health, safety, and welfare of the association and the owners and their family members, tenants, guests, agents, or invitees, and to mitigate further damage, injury, or contagion. Contagion was added after the pandemic, and make emergency repairs. These powers include conduct meetings in whole or in part by telephone, real-time video, or similar real-time electronic or video communication. We know that everyone was doing Zoom meetings in the pandemic and continues. And to provide notice in as practical manner as possible, if it's not possible to do them otherwise. And notice of decisions may also be communicated in that manner. What else under the emergency powers? Cancel and reschedule meetings. Designate assistant officers who are not directors who will step into the shoes of the directors. Relocate or designate a principal office to an alternate location. Enter into agreements with counties and cities to assist the counties and the cities with debris removal. Implement a disaster or emergency plan before, during, or following the event for which the state of emergency was declared. For example, turning on or shutting off elevators, electricity, water, sewer, security systems, air conditioners, etc. Determine that any portion of the common area to be unavailable for entry or occupancy by owners or their family members, tenants, guests, agents, or invitees to protect their health, safety, or welfare based on the advice of emergency management officials, public health officials, or licensed professionals retained by or otherwise available to the board. Again, a lot of that language was incorporated, again, post-pandemic. Under these powers, the board can also determine whether the common areas can be safely inhabited, accessed, or occupied, again, based on the advice of emergency management officials, public health officials, or licensed professionals retained or by or otherwise available to the board, not retired. Mitigate further damage, injury, or contagion. For example, removing debris and wet drywall, insulation, carpet, cabinetry, or other fixtures on or within the common area, and sanitizing the common area. Levying of special assessments without a vote of the owners, notwithstanding a provision to the contrary in your governing documents, and regardless of whether such authority does not specifically appear in the governing document. So again, if you need money to perform repairs, emergency repairs, debris removal, you need a special assessment passed, you can do so on these emergency powers, even if otherwise your documents say you need owner approval for a special assessment. Similarly, without owner's approval to borrow money and to pledge the association assets collateral, and those assets are usually your assessments, by the way, as collateral to fund emergency repairs and carry out the duties of the association if operating funds are insufficient. This authority is in addition to an association's general authority to borrow money, and it's subject to any restrictions contained in your documents. Notwithstanding your emergency powers, there are certain things you can't do. So you cannot prohibit owners, tenants, guests, agents, or invitees from accessing the common areas and facilities for the purpose of ingress to and egress from the parcel or the lot when necessary in connection with the sale, lease, or other transfer of a parcel. Okay. This came up because during the pandemic, associations were prohibiting realtors from coming on the property or other agents. So they addressed that here. Or the habitability of the parcel, or for the health and safety of such person, unless a governmental order or determination or a public health service directive or public health directive from the Centers for the Disease Control, the CDC, has been issued prohibiting such access to the parcel. Any such access is subject to reasonable restrictions adopted by the association. All right, off of emergency powers now into debit cards. This is something that most people don't, I think, realize about the restrictions on associations to use debit cards. So under the statute, under Chapter 720, an association's officers cannot, association officer directors, employees, agents cannot use a debit card issued in the name of the association or billed directly to the association for the payment of any association expense. A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not a lawful obligation of the association commits theft. So what's a lawful obligation? A lawful obligation means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the written budget. You can also sue. In other words, the association is able to bring lawsuits on behalf of the association for certain things. Among them, or they are, matters or issues dealing with the common area, roof or structural components of a building or other improvements for which the association is responsible, mechanical, electrical, or plumbing elements serving an improvement or building for which the association is responsible. You can also initiate lawsuits regarding the representations of the developer pertaining to any existing or proposed commonly used facility, protesting ad valorem or property taxes on commonly used facilities, not the lots, on the common areas, and defending an eminent domain lawsuit and bringing an inverse condemnation claim. However, before commencing litigation, this is commencing, not defending, before commencing litigation against any party in the name of the association involving amounts in controversy exceeding $100,000, you must obtain the affirmative approval of majority of the voting interest at a meeting of the membership. So if you're going to bring a lawsuit against a developer for construction defects for $1 million, since that's in excess of 100,000, you need to get the owner's approval in advance. Just an example. Architectural control. This is something that you're going to be dealing with most likely on a pretty frequent basis. And this is important because the law was changed regarding architectural standards and guidelines and control back in July of 24, so not that long ago. An association must reasonably and equitably apply and enforce on all owners the architectural and construction improvement standards or other published guidelines authorized by the declaration. Now, the second bullet point is crucially important. If the association denies an owner's request or application, and that by association, that means board or your ARB or ACC or whatever committee your documents may authorize. So if an owner's request or application for the construction of a structure or other improvement and they're denied, the association must provide written notice to the owner stating with specificity the rule or covenant on which the association relied when denying the request or application and the specific aspect or part of the improvement or the proposed improvement that does not conform to such rule or covenant. So what this is saying in essence is you need to adopt and look at your documents for the approval process, architectural standards and guidelines that are written, that are specific regarding architectural control in your community, whether that's color, material, style, design, or whatever, okay? And if someone gets disapproved or denied approval, then you have to basically give them written notice specifying, okay, why their application was denied and stating with specificity what rule, what covenant, what guideline it didn't comply with and why it didn't comply with that guideline. It's very, very important. Otherwise, you're going to have a difficult time in a courtroom succeeding if there's any litigation arises out of that denial or that disapproval. So again, this is crucially important. Another thing I'm going to mention here, even though it's not here in the guideline, certain committee meetings of an HOA must be open to the members. One of those committees that must be open to the membership is meetings of your architectural control or your ARB committee. Okay, when they're meeting to decide an application, that is a posted open meeting. An association cannot enforce or adopt a covenant, rule, or guideline that limits or places requirements on the interior of a structure that is not visible from the lot's frontage or an adjacent lot, an adjacent common area, or a community golf course. You can also cannot enforce a covenant or guideline that requires the review and approval of plans and specifications for a central AC, refrigeration, heating, or ventilating system by the association if that system is not visible from the parcels or the lot's frontage, an adjacent parcel, an adjacent common area, or a community golf course, and it is substantially similar to a system that is approved or recommended by the association. This next one is also pretty new. Items on a parcel, regardless, again, in the statute, regardless of any covenant, restriction, bylaw, rule, or requirement of an association, and unless prohibited by general law or local ordinance, an association may not restrict, again, may not restrict owners or their tenants from installing, displaying, or storing any items on a parcel which are not visible from the lot's frontage or an adjacent lot, or an adjacent common area, or a community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. So, people have this stuff on their lot, but it's not visible, as we just mentioned in this statute, then it's not, it's not a violation. Hurricane protection is also pretty new with respect to HOAs as far as the statute provides. Every association is required, it must adopt hurricane protection specifications for each structure or other improvement on a lot governed by the association. So what does that include? Well, hurricane protection includes, and without limit, roof systems, permanent fixed storm shutters, roll down track storm shutters, impact resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generators, fuel storage tanks, and other hurricane protection products used to preserve and protect the structures on a parcel. These specifications must comply with the applicable building code and may include the color and style of hurricane protection, any other factor deemed relevant by the board, again, as long as those specifications also comply with code. The association cannot deny an application for the installation, enhancement, or replacement of hurricane protection by an owner which conforms to the specifications adopted by the association. However, the association may require an owner to adhere to an existing unified building scheme regarding the external appearance of the structure or other improvement on the parcel. For example, in my opinion, let's say every roof in this community is barrel tile, okay, of a certain color or colors. And an owner says, no, I want a metal roof because they're really great for hurricane protection, da 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 da. Well, that may be true, but if there is a unified building scheme that all the roofs are barrel tile, notwithstanding that that metal roof is, good for hurricane protection, I think they can enforce the unified plan of development. Now, talk to your own counsel. He or she may disagree with me. That's fine. Okay. But that's how I read this unified building scheme, as meaning you can still enforce that with respect to your community and in regard to your hurricane specification guidelines or requirements. Vehicle restrictions. This is an issue that is crucially important. I'm going to relate back to a discussion we had a while ago about Kaufman and how changes in the law affect your documents, because it's all wrapped up in this vehicle restrictions. Okay. Effective of July July of 24, okay, your documents cannot prohibit an owner, tenant, guest, or invitee from parking his or her personal vehicle, which specifically includes a pickup truck in the law, in the owner's driveway or in any other area at which the owner, tenant, guest, or invitee has a right to park as governed by state, county, and municipal regulations. Also, in the same statute, an owner, tenant, guest, or invitee cannot be prohibited from parking his or her work vehicle, regardless of any official insignia or visible designation, which is not a commercial vehicle as identified in section 320.0125 in the owner's driveway. Okay, by the way, a commercial vehicle under that statute is basically a dump truck. It's a vehicle that weighs over 26,000 pounds. So huge. But why has this created a lot of controversy? Why is this issue important? Well, the statute was adopted July 1st, 2024. Many association documents in existence prior to that time prohibited, for example, trucks or pickup trucks in a driveway. This statute says, well, now they're permitted. So what does that really mean in terms of those pre-existing documents? In our opinion, and I think in the opinion of many who do what I do, okay, unless your declaration has what's known as Kaufman language, which it adopted future amendments to Chapter 720, it said, it's subject to Chapter 720 as amended from time to time. If your document or if your declaration had that language, then it did incorporate that new statute. And I think that would invalidate your existing restriction against, let's say, pickup trucks on a driveway. However, if it did not have that Kaufman language, then in our opinion, since this is a substantive change to the law, it would not apply retroactively to invalidate that existing otherwise legal restriction, either on trucks or commercial vehicles, which are not the size of a dump truck. So in this example or in this issue, to see whether or not your vehicle restrictions are still enforceable, okay, you can't adopt new ones now prohibiting these things because the law has been changed as of July 24. But if you had a pre-existing vehicle restriction, that now conflicts with this statute and you did not have Kaufman language, then we think that those existing vehicle restrictions are still enforceable. There's no case law on this yet. There's no appellate court has addressed this yet. So who knows what will really happen. But based upon the fact that you can't apply substantive laws retroactively, we think it's a pretty good position that those existing vehicle restrictions, if lawful when they were adopted, are still enforceable in the absence of Kaufman language. Okay. Also effective July 1, 24, you cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on the owner's lot solely because the contractor or worker is not on a preferred vendor list. You can also not prohibit an owner from bringing on a contractor on the lot because the contractor does not have a professional or an occupational license. So basically, the association may not require that the contractor hired by an owner present or prove possession of a professional or occupational license to work on that owner's lot. Now we're going to move into budgets and reserves. You must prepare an annual budget. That annual budget is required to reflect the estimated revenues and expenses for the upcoming fiscal year and the estimated surplus or deficit at the end of the current fiscal year. So don't lowball your budget if you know you're going to have expenses of X and you lowball your budget to Y because you don't want to raise assessments. And that is not the proper way to budget. You have to set out separately all fees or charges paid for by the association for recreational amenities, whether owned by the association, the developer, or another system. This may or may not be applicable to you, obviously, but if it is, it has to be disclosed. Your budget has two components, operating and reserves, if any. As a practice tip, use last year's actual expenses as a blueprint or a plan for next year's budget. However, if you know that last year's budget is low, was low, or you know that you have additional expenses coming up, you can't just rely on last year's budget. You have to plan accordingly. It's good to use as a base or as a foundation for next year's budget, but you do have to plan accordingly for what are your estimated expenses for the upcoming fiscal year. Now, your operating budget, those money, they can be used for anything you want. Okay. There's no restriction on any particular purpose. And even though it's in a line item, maybe in your operating budget, the board can move those items around as needed to pay the association's operating expenses. Unless your governing documents have a specific provision that prohibits that. What are the operating expenses? So that's your day-to-day operation, basically your recurring expenses as opposed to reserves or non-recurring expenses. So those expenses, run the gamut, anything from the administrative and management fees, the maintenance and repair, landscaping, repair, pool maintenance, whatever other things you're, maintaining on a day-to-day basis. Rent, if there is any rent for recreational other use facilities. That's more of a condo thing for older condo associations, but your HOA might have recreation area rental. Taxes on association property or lease property, your insurance costs to insure the common area, or perhaps insure the lots, because in townhome communities, oftentimes the association does insure the homes as well as the common area. So you got to check your documents. If you do maintain insurance for the homes, that's obviously part of your operating expense. And professional fees, accounting fees, legal fees, etc. Engineering fees as well. Now, the budget may include reserves in addition to operating expenses. There's huge difference between HOAs and condos regarding reserves. I'm going to mention it because people sometimes get confused, or when they hear reserve, they think of a condo reserve, or they've heard about condo reserves, or that's what they're used to. So they apply the same law, and it's completely different between an HOA and a condo when it comes to reserves. Okay, so what are reserves? Well, reserves are either for capital expenditures or for deferred maintenance. A capital expenditure is any expenditure of funds for the purchase or replacement of an asset whose useful life is greater than a year, or repair to an asset that will extend its useful life of the asset for a period of greater than a year. Deferred maintenance is any maintenance repair that will be performed less frequently than yearly, okay, and will result in maintaining the useful life of an asset, okay? So you have basically replacement or acquisition as opposed to repair expenses that are non-recurrent or don't recur on a less than an annual basis. Now, what are examples of these things? And these can fit into both categories: resurfacing of the pavement, repairs, improvements to common area association property, such as, putting a new roof on the clubhouse or painting the clubhouse, those kind of things. They're done, but they're not done, as a daily thing. Sidewalk improvements. So all these, more capital and deferred items, these are reserve items or can be reserve items. Now, here's where the huge difference is between condos and HOAs. And I'm going to go off script here slightly. In condominiums, the condominium association must budget, okay, for reserves and must maintain reserves unless the owners vote to waive or reduce them. But for condos, I'm really going off script here. If you have a condominium with buildings of 3 stories or more, they're now required to keep what's known as structural integrity reserve funds, and they must maintain those. They can't even waive those. HOAs, okay, that was condos. Condos very, very, very different. HOAs, your only mandatory reserves, if you have any, are reserves that are created upon the affirmative vote of approval of a majority of the total voting interest of the association. So if your owners, by a majority vote, of the total voting interest require the association to maintain reserves, now you've created for an HOA purpose a statutory reserve, subject to all the restrictions. However, if the reserves are just created by the board, then they're pretty much to be used for however the board wants, and they're not locked in like they are in a condominium, where the reserves are locked in and they're restricted, and it's very specific about how they're maintained, how they're calculated, and how they're used. In an HOA, you're only locked in if the membership has voted in the approval of maintaining reserves. So board made reserves in an HOA, again, pretty much open season. So upon approval by the membership, and the board must then include the required reserves in the budget of the next fiscal year following the year the membership vote was taken, and each year thereafter. By the way, in my experience, I don't think any association that I represent has had membership approved reserves. So it doesn't mean it's not out there, and I just haven't seen it. Once established by a membership vote, the statutory reserve accounts must be funded, maintained, or waived in the manner provided by statute, such that, i.e., statutory reserves may be waived or partially funded only upon a vote of a majority of the members present at a meeting in which a quorum is present. Reserves, this last bullet point is important, I already mentioned it, created any other way are not subject to the calculations and restrictions on the use of such funds set forth in the statute. So reserves created by the board, okay, they can be used, they can be funded, they can be moved around, switched to operating, however the board decides, okay? They're not locked in. Now, your documents, I should mention this, if your governing documents require reserves and require reserves to maintain a certain way, then you have to comply with that. But I'm assuming your documents don't have that and the membership has not voted in reserves, then the board is free to do what it reasonably determines in its business judgment. Calculating reserves. Okay. Assuming you have statutory reserves, then the amount to be reserved for a statutory reserve is based upon the estimated remaining useful life and estimated replacement cost or deferred maintenance of each reserve item. The association may adjust reserve assessments annually to take into account any changes in estimates of the cost or useful life of the reserve asset or item. Funding formulas for statutory reserves must be based on a separate analysis of each of the required assets or a pooled analysis if you have two or more. So if you have a pooled reserve account pursuant to a statutory reserve account, made voted in by the membership, then you can, that calculation is different because it's based on all the items that are in the pool as opposed to individual items. Unless the association maintains a pooled account of reserves, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with the following disclosures, minimum disclosures: total estimated useful life, estimated remaining useful life, estimated replacement cost or deferred maintenance expense, and estimated fund balance as of the beginning of the period for which the budget will be in effect. For those board members who are new, okay, and you're not sure whether you have reserves, don't have reserves, how were they created, look at your reserve, look at your budgets, try to find out if you have reserves, how were they established? Were they established by a board vote or were they established by a membership vote? Again, to the 18th time, I guess I'm going to repeat myself. If by a board vote, there really is no limit or restriction on those reserves or how they're used or how they're calculated. If they were created pursuant to a membership vote, then they are subject to the statutory limits and restrictions. So using reserves for other purposes, statutory reserves, the reserve funds and interest must be used in the reserve account or must remain in the reserve account, only used for those authorized reserve expenditures, unless they're used for other purposes approved in advance by majority vote. Again, statutory reserve. Pooling reserves, the association may also establish pooled reserve accounts instead of or in addition to individual reserve accounts. If the association establishes a pooled reserve account, statutory reserve account, for two or more reserve items, funds may be withdrawn from that account only to pay for any of the items in that pooled account. The difference between an individual reserve line item account and a pooled account is that instead of each individual reserve having its own fund balance that can only be used for that purpose, the money in a pooled account is available for all items. Again, all of these things dealing with statutory owner approved reserves. And that's, in my experience, still relatively rare. After one or more statutory reserve accounts have been established in accordance with Chapter 720, The proposed budget must include the statutory defined reserves, and the association must fund those reserves. Unless the majority of the voting interests represented at a duly called membership meeting at which quorum is present, vote to either waive or reduce funding, partially fund of the reserves. The vote to waive or partially fund is only applicable to one budget year, the year that the vote was taken, one fiscal year. Whether to submit a vote to the membership to waive or partially fund statutory reserves is a board decision. So if you have statutory reserves, whether or not to vote to waive them or partially fund them is a board decision, whether or not to throw that issue to the owners. What about terminating statutory reserves? Reserve accounts established pursuant to the statute, again, pursuant to an owner vote, may be terminated upon the vote of majority of the total voting interests, not a majority of a quorum, but the total voting interests of the association. And upon that approval, the terminated reserve accounts are then removed from the budget. Notice and adoption of the budget. Again, very different than a condo again. The governing documents must be reviewed for any specific budget meeting notice and adoption requirements because the HOA Act, quite frankly, does not contain specific notice or agenda requirements for budget meetings. Condo Act does. The Condo Act is very specific about board meeting notice to adopt the budget. The HOA law, not so much. However, check your governing documents because they may have a specific notice and procedure in there. If the governing documents, however, are silent, your HOA documents are silent regarding the budget adoption process, then notice of the board meeting at which the proposed budget will be considered and adopted must be conspicuously posted at least 48 hours before the meeting. And since you're be concerning with the adoption of assessments, which is a budget, got to make sure that the agenda expressly indicates that the board is going to be considering the adoption of the association's budget. Unless the governing documents require the board to provide a copy of the proposed budget to all owners, you're not required to do so. But you know what? As a practical matter, as a matter of good business practice, we consider sending out that proposed budget to all the owners before the board has a meeting to consider its adoption. After it's been adopted, the association must provide every owner with a copy of the budget or written notice that it's available upon request at no charge. If requested by an owner, a copy of the adopted budget must be provided to the member within the time frame set forth for the inspection of records. In other words, within 10 business days of receipt of the request for a copy of the adopted budget. And by January 1, 2025, okay, an association with 100 or more parcels must post a copy of that budget on its website or app. Assessments and foreclosures. I think we mentioned this already. To mention again, written notice of any board meeting at which the board is going to consider the adoption of a special assessment must be mailed, delivered, or electronically transmitted to the members and posted on the property at least 14 days in advance. Again, only electronically transmitted to those owners who agreed to receive notice that way. That notice must include a statement that a special assessment will be considered and the nature of the assessment, and it must identify or should identify, the estimated cost. I would have the cost, the nature, right in that meeting notice, the purposes of the special assessment. Once levied, the association should send the written notice to the owners of the special assessment and allow the owners a reasonable time to pay it. Your governing documents may expressly address that, though. It may say how much time period the owners must be provided to pay an assessment, pay a special assessment. If so, you must follow that provision of your documents. And a special assessment which has not been paid, and then it's collected in the same manner as a regular assessment. In other words, through the lien and foreclosure process. But as I mentioned a while ago, if you don't properly adopt that assessment, in other words, you didn't do the proper meeting notice, you didn't send it to the owners and post it 14 days in advance, or you didn't have the right information in the agenda about the special assessment, then that's going to be a defense to an owner to pay that special assessment. Requirement to provide an accounting, also relatively new. A parcel owner may make a written request to the board for a detailed accounting of any amounts that owner owes to the association related to that owner's lot, and the board must provide that accounting information within 15 business days after receipt of the owner's written request. After a parcel owner makes such a written request, he or she may not request another detailed accounting for at least 90 days. So they can't be sending this to you every month, okay? There's a 90-day period before they can ask again. However, if the board fails to respond within 15 business days to a written request for that detailed accounting, that is a complete waiver of any outstanding fines that that person who requested such accounting may owe, which are more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fine. So certain fines may be waived, okay, if the association fails to provide a timely response to the request for the accounting. Now, what about the collection of assessments? If they're not paid when due, they bear interest at the rate provided by your documents, declaration of bylaws. If the documents are silent as to that rate, then the rate is 18%, which is the current maximum amount allowed by law. Notwithstanding what the DEC or bylaws may say, the declaration may say, compound interest may not be accrued on assessments and installments on assessments that are not paid when due. Late fees. An administrative late fee not to exceed the greater of $25 or 5% of the amount of each installment may be imposed if permitted by declaration of bylaws. In other words, your declaration or your bylaws must authorize the imposition of a late fee. However, you cannot charge interest on interest or interest on a late fee, okay? And it's only one late fee per delinquent assessment. So if the owner doesn't pay their February assessment, let's say, or the February installment, and you hit them with a late fee, that assessment still hasn't been paid in March, and they also missed their March installment of assessment. If it's monthly, you could hit them with another late fee for March, but not a second late fee for the delinquent assessment in February. So you can't pile on the late fees on top of each other for one delinquency. And also, again, your documents must have the authority to charge a late fee. If your documents have a lower amount, in other words, older document says you can only charge a late fee of $10, then you're stuck with the $10, okay? So check your documents for a late fee authority. Don't assume you have it, and it's not a board rule. Again, it must be by declaration provision or in your bylaws, not by a rule. The association is also entitled to collect attorney's fees and costs incurred in the collection of any delinquent assessments. It says, see notice of late assessments. We're going to talk about that shortly. How do you apply payments? Let's say someone makes a partial payment or less than what they owe. You do accept it. Don't turn it away. Don't send it back, but you apply it in a certain way. Any payment received by an association must be applied first to any interest that's accrued, then to any late fee, assuming you have the authority to charge it, then to any costs and reasonable attorney's fees incurred in collection, and finally to the delinquent assessment. So it's applied to all that other stuff first, and then the actual delinquent assessment last. And restrictive endorsements are not enforceable by the owner. The association cannot require payment of attorney's fees related to a past due assessment without first delivering. So we mentioned before that the association can collect attorney's fees incurred in the collection process, but there is a precondition, okay? Before you can charge an owner attorney's fees related to collection of delinquent assessments, you have to provide that owner what's known as a written notice of late assessment, and that's in the statute, notice of late assessment to the owner, which specifies the amount owed the association and provides the owner 30 days to pay the amount owed without the assessment of attorney's fees. The form of that notice is set out in the statute, specifically 720.3085, okay? You must substantially conform your notice of a late assessment to that statutory form. That notice of late assessment must be sent by first-class U.S. mail to the owner at his or her last address as reflected in the association records. And if it's not the lot address, you also must send it to the lot address. So let's say the owner is in New York, okay, New Jersey, whatever, and they've given that address to the association as their address, you know, my address in New York, my address in Jersey. Then the notice of late assessment has to be sent to that address as well as the lot address. You got to send it to both. If their only address is the lot address, then it only goes to the lot or the parcel address. Finally, there's a rebuttable presumption that the association mailed the notice in accordance with the statute. That's established if a board member, officer, or agent of the association or a licensed property manager provides a sworn affidavit attesting to such mailing. So when we do collections here, we require that affidavit. We require to see a copy of the notice of late assessment, because if this isn't complied with, you're not going to be able to charge that owner attorney's fees incurred in the collection process unless you first comply with the notice of late assessment requirements. Okay, you've done that. They still haven't paid. You did the NOLA, the notice of late assessment, you did it correctly. They still haven't paid. Now what do you do? Okay, you have a right to put a lien on that lot, that parcel, for unpaid assessments. You can file the lien, and that's recorded in the county in which the lot is located, and that secures unpaid assessments, interest, late fees, if applicable, and attorney's fees and costs. That letter or that notice is sent by certified mail, and it must give the owner at least 45 days to pay and indicate the intent to record a lien if the owner does not pay everything that is due. So it's a 45-day notice before you can put that lien on. So first it's a 30-day notice, and then if they haven't paid, then it's the 45-day intent to lien notice. Let's say they still haven't paid after the 45 days. Then you can record a lien, okay? You must provide owner another 45-day notice with a copy of that lien before you can foreclose the lien in court. So those are your time periods: 30-day notice of late assessment, a 45-day notice of intent to file a lien, and then after that, a 45-day notice of intent to foreclose that lien. Those are the time periods that are minimum time periods that are applicable to getting to a foreclosure on a collection. What about a first mortgagee that acquires a lot by foreclosure or deed in lieu? What do they owe? Well, the liability of a first mortgagee, lender, or its successor assigned who acquires a lot by foreclosure or deed in lieu of foreclosure is limited. Okay, it's the lesser of the lot's unpaid common expenses and regular, periodic, or special assessments that came due during the 12 months immediately before the acquisition of title, and for which the association has not received payment, or 1% of the original mortgage debt. So it's the lesser of those. The lesser of 1% of the original mortgage debt, or 12 months of past due assessments, basically. However, please note that that limit on what the first mortgagee owes, okay, only applies if the first mortgagee named the association, initially joined the association as a defendant in their foreclosure action. So almost always the first mortgagee, when it serves a foreclosure on the owner, will also serve that on the defendant, on the association as a defendant, because they're required to, in order to take advantage of the, what we call the safe harbor, or paying less than what is totally due if they acquire title. What about a third party bids at the foreclosure? A third party bidder, someone buys foreclosed property, has joint and several liability for any past due assessments. So they are going to be liable. However, if the association has foreclosed and taken title to the lot, and then the lender forecloses, a third-party bidder is not liable for assessments that accrued during the period the association owned the lot. We had many associations that owned lots during the, what I'll call the Great Recession. Was it 05, whatever, 04, 05, or beyond that. And in that times, many associations foreclosed on properties and took title to them. I haven't seen it so much recently. Financial reports. Every year you're required to do an annual financial report, okay? Either the association prepares it, or more typically a third party prepares it, accountant, whoever. And that's a financial report statement with regard to the preceding fiscal year. So that has to be prepared within 90 days of the end of the fiscal year, or annually on such date provided in the bylaws. So check your bylaws, they may have a different time period or a different date. Within 21 days after the report is completed, but no later, or received, but no later than 120 days after the end of the fiscal year, again, or other date that's in the bylaws, the board must provide every member a copy of the financial report or written notice that a copy of the financial report is available upon request at no charge. What level of reporting are you required to do? Well, that's going to depend upon the amount of the association's revenue for the applicable year. So If your annual revenue for the year for which the report is being prepared is less than $150,000, so it's a very small association, that's a report of cash receipts and expenditures. If it's 150,000 or more, but less than 300,000, it is a compilation or a compiled financial statement. If it's 300,000, but less than 500,000 in revenue, it's a reviewed financial statement. And if your revenue is 500,000 or more, then it's an audit. However, notwithstanding what your annual revenues may be, if your documents provide that you must do a certain level, such as an audit, then you have to do the audit, notwithstanding what your revenue was. So in the absence of your documents expressly providing something otherwise, you have to follow these requirements. As of July 1st, 2024, though, notwithstanding what your revenues are, if you have 1,000 or more lots, okay, then you have to do an audit. Yeah, for a large community. What about having a level higher than what is ordinarily required because of your revenue? Well, if 20% of your owners petition the board for a higher or a greater financial reporting requirement or financial statement than required, then you must notice and hold a meeting of the members within 30 days of receipt of that petition to vote on raising the level of the reporting for that fiscal year. If it's approved by a majority of the total voting interest, then you must prepare or cause prepared a higher level. And I won't read all this. Basically, that higher level can be whatever level above that the owners wanted in that vote above what you otherwise would have had to do. A copy of that financial report, the higher prepared report, must be provided to the members within 90 days of the meeting or the end of the fiscal year, whichever is the last or the later to occur. And you must amend your budget or adopt a special assessment to pay for that financial report if it's not, regarding any provision to the contrary that's in your governing documents. I have never seen an association have their owners petition for a higher level, but I guess it's been done. What's more common is the owners voting for a lower level or a lesser financial report. Again, assuming your documents don't require the higher level anyway. So if approved by a majority of the voting interest present, not a majority of all, but a majority present at a meeting in which a quorum is obtained, and a present can be, by the way, in person or by proxy, unless your documents prohibit proxy voting, you can prepare, a lesser level. So what does that mean? So you can do a report of cash receipts and expenditures rather than compiled, reviewed, or audited, or cash receipts and expenditures, or compiled in lieu of reviewed or audited, or cash receipts compiled or reviewed in lieu of an audit. Okay, if an audit is your category. However, an association may not prepare a financial statement at a lower level for consecutive fiscal years. So if your owners voted, for example, now to have a lesser report for the 2025 fiscal year, okay, then in 2026, they can't do that again, and you'll have to prepare the level at which your revenue is required. You can't be lower. I'm not going to go through this slide. It's basically for your financial report, it must have certain disclosures regarding reserves and whether or not they're maintaining or not retaining reserves. I will skip this one because this is not something that you guys are going to be preparing anyway. Contracts and bids. Okay. Contracts must be in writing if the contract cannot be fully performed within 1 year for the purchase or release of materials and if it's a service contract. I would recommend that every contract, quite frankly, be in writing. Okay. I think that's just a general rule of thumb and a better way to operate the association. All written contracts entered into by an association for the operation, maintenance, or management of the association or property should specify, again, it's not a must, but should specify. In condos, they have a must. But for you guys, it should specify the obligations of the party contracting to provide management or maintenance services, the cost for each of these services, the frequency of the services, and the minimum number of personnel to be employed. Again, the more specific the contract, quite frankly, the better in terms of what services are being performed and the cost and how frequently those services are performed. What about bidding? This is different than the condominium law. In condominium, it's any work that costs more than 5% of your budget. However, for HOAs, what we're talking about today, if the aggregate cost of the contract is more than 10% of the total annual budget, including any reserves, you must obtain competitive bids for materials, equipment, or services. By the way, that doesn't mean that if it's less than that, you don't have to get bids. This just means that if the contract is more than 10% of your total budget, you must obtain competitive bids. You're not required to accept the lowest bid, by the way. If it's a bona fide emergency, you're not required to obtain the bids for products and services, but it has to be a bona fide emergency, okay? And I don't think it's an emergency. I don't think, in my opinion, it's not an emergency if, we're heading towards winter and all the board members are leaving, or heading towards summer and whatever it is, the seasons are changing and the board members are moving around. That's not an emergency, okay? It has to be a bona fide emergency like a hurricane or something like that. Or if the association is not required to obtain competitive bids for products and services, or when the business entity with which the association desires to contract is the only source. So emergencies, or there's only one contractor that's the source of that service or those products, then you don't have to get bids. Contracts executed before October 1st, 2004, just a while ago, and a renewal thereof are not subject to the bid requirements. There's also exemptions for the following from your bidding. So contracts with employees, if any, attorney, accountant, architect, manager, okay, engineer and landscape architect. These are not required to be set out or be set forth for competitive bidding. These contracts must be in writing, and quite frankly, even though it's not required to be bid, there's certainly no preclusion from obtaining bids for these services. Not from employees generally are not going to be giving you bids, but the other ones, yes. An estoppel certificate, okay? This is with respect to the sale or conveyance of a lot. Estoppel being basically a legal word for reliance or detrimental reliance. So when a lot is being sold or conveyed, typically they will ask for an estoppel certificate. Within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner or a lender, mortgagee, or their designees, like a title company or something, the association must issue the estoppel certificate. You must designate on your website a person or entity with a street or email address to receive the estoppel certificate requests. Estoppel certificates must be completed by a board member, an authorized agent, or authorized representative of the association, including any authorized agent, representative, or employee of the association's management company. So those are the ones authorized to issue it. Estoppel certificates must be provided by hand delivery, regular mail, or email on the date of issuance of the estoppel certificate. And they must be signed by an officer or authorized agent of the association. So it's completed by a board member, agent, or authorized representative, and signed by an officer or authorized agent. So what goes into it? What are the contents? Date of issuance, name of the owner, that means the current owner, as reflected in the books and records of the association, the property designation and address, a parking or garage space number as reflected in the books and records of the association. If there's any assigned parking space, that must be designated. If this lot is in collections, then you need the attorney's name and contact information if that lot is in collection with that attorney. The fee, and we'll talk about fees in a second, for the preparation and delivery of the estoppel certificate, and the name of the party requesting it. The assessment information. This is really the meat now of the estoppel. You have to include the amount of the regular periodic assessment levied against the lot and the frequency of the assessment. So, if it's $100 a month, you say this lot pays $100 monthly. If it's $1,000 quarterly, then you say it's $1,000 due quarterly, whatever the periodic assessment is and the frequency. The date that regular periodic assessment is paid through, the date of the next installment that is due, and the amount. Okay, so monthly, quarterly, whatever. Itemized list of all assessments, special assessments, and other monies owed on the date of issuance to the association by the owner of the specific property. So what does this lot owe you as of the date? What do what do they owe? And list all the assessments and all the monies owed as of the date that you're issuing this estoppel. Itemized list of any additional assessments, special assessments, and other monies that are scheduled to come due for each day after the date of issuance for the effective period. And we're going to talk about that in a second. What is the effective period of the estoppel certificate? In calculating the amounts that are scheduled to become due, the association may assume that any delinquent amounts will remain delinquent during that effective period. What else goes in there? All right, is there any kind of capital contribution fee, resale fee, transfer fee, or other fee due, and the type and amount of the fee of the fee? Whether there is any open violation of a rule or regulation noticed previously to the owner of the property in the official records. And this is important because you want to put the next owner on notice of written notice provided to the current owner about a violation. So the next owner can't say, hey, I wasn't made aware of that. Okay, so if there's an open violation that you provided written notice to the current owner about, that has to be included in the estoppel. Whether the rules and regulations of the association applicable to the property being transferred require approval of the board, and if so, whether or not the board has approved the transfer. So not every HOA has approval process for sales and transfers. If you do, and you have to indicate whether or not, that sale or transfer has been approved. Whether there is a right of first refusal provided to the members or the association, and if so, whether the members of the association have exercised that right of first refusal, i.e. to match the sale price in the terms of the sale. And this is pretty rare for an HOA, but if you do have it, then you have to include it, indicate whether that first refusal has been exercised. A list and contact information for all other associations for which the association is a member. So if this association is a sub-association and is a master association that the owner is also required to be a member of, then you have to indicate the contact information for that other association or associations that this lot is required to be a member of, or the owner is required to be a member of. Contact information for all insurance maintained by the association. That's usually the contact information as far as name, address, phone of your insurance agent, the association's insurance agent. What are the fees? If this lot is current and there's no delinquency, you can charge a fee up to $250 to issue the estoppel. If it's delinquent, you can add another $150. If they want it on an expedited basis, in other words, they want to do a closing right away, and they want that closing within 3 business days after the request, you can add another $100 to the estoppel fee. In order to charge an estoppel fee, the authority to do so must be established by a written resolution adopted by the board or provided by a written management, bookkeeping, or maintenance contract. So you need the authority to charge the fee in a resolution adopted by the board or set forth in a contract with the management, bookkeeping, or maintenance agreement. If you fail to provide the estoppel request certificate or the estoppel certificate in response to request within the 10 business days, then you waive the right to collect these fees. If the certificate is requested with respect to the sale or mortgage of a property, but then the closing does not occur, and no later than 30 days after the closing date for which the certificate was sought, the preparer receives a written request accompanied by reasonable documentation that the sale did not occur, then the fee must be refunded. So if the sale doesn't occur or the closing doesn't occur and they send you written notice, then you have to refund the fee if they give you that information, within 30 days. We talked about effective period. Remember, the estoppel is good for a certain amount of time, and you have to list like what assessments or other monies are coming due within that effective period. Well, if it's issued by hand delivery or email, then the estoppel certificate is effective for 30 days. If it's delivered or issued by regular mail, old-fashioned snail mail, then it's effective for 35 days to take into account the mailing time. If additional information or a mistake related to the estoppel certificate becomes known to the association, oops, we forgot to include a special assessment that was delinquent, or we forgot to include whatever, okay, you can issue an amended estoppel certificate, okay, and that becomes effective if the sale has not been completed. In other words, during the effective period, you cannot charge a fee for the amended estoppel certificate You can get it out. You can't charge another fee for it. And it's good for a new 30 or 35-day period, depending on how it was issued. Okay. Really, really important is the language at the bottom here in red, orange, whatever color that is. An association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon it. And from the person, so in other words, if you get a request for an estoppel certificate and that lot is $10,000 delinquent and you, forgot to include that, or you didn't include all of it, you're not going to be able to collect it. You waive it. So it's really, really important that when you issue an estoppel certificate that you capture all the monies that are owed to the association and you disclose any special assessments that are coming due or other assessments or other charges within that effective period from when it's issued. Otherwise, you're going to waive your ability to collect that money. Covenant enforcement. Okay. Whoops. Covenant enforcement. You have to enforce your documents. Okay. You enforce them as uniformly as possible. That's either your covenants, your rules, both. Okay. And it's a gamut of issues that you're dealing with: architectural standards, pets, leasing, parking, nuisance, whatever. There's lots of different things that could be violations of your governing documents, whether it's your declaration or your rules. Now, if you fail to enforce them in a timely manner, then you may end up waiving the ability to enforce them because you haven't enforced them timely. Also, if you don't enforce them consistently, okay, if you're inconsistent with how you enforce certain rule, certain covenant, then that gives a rise to the defense of selective enforcement, that an owner can say, hey, you didn't enforce against these other 5 owners, you can't enforce against me. So that's an affirmative defense to enforcement. Typically, the first step in enforcing your covenants, enforcing your rules, is providing the owner written notice of the violation, including a statement of it, the provision that's being violated, covenant, rule, or both, and an opportunity to cure if applicable. Let's say you don't get compliance. Then what do? Right? We throw them in jail. Well, no, that's not in the law yet, but the violation may become subject to certain enforcement actions, including fining, not my favorite, but we'll talk about it, suspension of use rights, suspension of voting rights, subject to certain monetary issues, self-help, if authorized by your documents, mandatory pre-suit mediation, and finally, litigation or filing suit. So we're going to talk about these. Fines and use rights. You have the authority to fine and suspend an owner's right to use of the recreation and common facilities for failure to comply with your governing documents. However, you cannot impose a fine or a use right suspension unless the board first levies the fine or imposes a suspension at a properly noticed board meeting. So the first thing is the board, at a duly noticed meeting, levies the fine and or the suspension. Okay. Then the board must provide the owner, the violating party, with 14 days written notice of a hearing of on the alleged violation. That notice must provide a description of the violation, the specific action required to cure the violation, if applicable, and the date and location of the hearing and access information if the hearing is to be held by, let's say, telephone or other electronic means, like video conference. That hearing, it's a 14-day notice, must be held within 90 days after the issuance of the notice. Who is the party for the association that conducts the hearing? Well, that's a committee, okay? That committee must be at least 3 members appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. By the way, if you don't have a committee, you can't impose a fine or suspension for these violations. The role of the committee is limited, okay? It's like a little appellate body because it's limited to determining by a majority vote whether to confirm or reject the fine or use right suspension imposed or levied by the board. It cannot change it. It cannot change the amount of the fine, cannot change the suspension. They only approve it or reject it, or confirm it or reject it. If the committee does not confirm the fine or suspension, it cannot be imposed. So the board cannot overrule the committee. The committee has the final say on whether or not that fine or suspension is imposed. The committee may hold the hearing by telephone or other electronic means, and the owner has a right to attend the hearing by telephone or other electronic means. Within 7 days after the hearing, the committee must mail or email written notice to the violating party of the committee's findings, including any applicable fine or suspension that the committee approved or rejected, how the violation can be cured, if that's applicable, and the date by which the fine must be paid. Now, if the violation has been cured before the hearing or in the manner specified in the hearing notice or notice of the committee's findings, fine cannot be imposed. By the way, what you really want is you want compliance. The amount of the fine, quite frankly, not really important. It's just it's kind of a stick to get them to comply. What you're really seeking here is compliance by the owner or the tenant, whoever, that the violation gets cured. That's really the key. If a violation is not cured, though, and the fine levied by the board is approved by the committee, remember, they have the final say, the committee must set a date by which the fine must be paid, and that date must be at least 30 days after delivery of the notice of the committee's findings. And attorney's fees and costs may not be awarded against the parcel owner based on actions taken by the board before the date set for the fine to be paid. If a violation and the fine levied by the board is approved by the committee and the violation is not cured or the fine is not paid per that notice or the committee's findings, then reasonable attorney's fees may be awarded to the association. How about, what are the amounts of these fines? And again, this is different than condos. A fine cannot exceed $100 per violation unless otherwise provided in your governing documents. Just for example, in a condominium, it's limited to $100. The documents can't go over that. In an HOA, though, your governing documents can allow the association to impose fines of greater than $100 per violation. Now, you can also levy a fine on the basis of each day of a continuing violation, but may not exceed $1,000 per violation in the aggregate, again, unless your governing document. So what's a continuing violation? Let's say someone has painted their door pink, blue, and orange, and those are not approved colors, and it was never approved, and you're going to fine. Well, that violation is continuing, right? Because it's pink, blue, and orange every day. So with a single notice and a single opportunity for hearing, you can levy a per day fine. But unless your documents don't provide otherwise, it's limited to $1,000 in total. If your documents allow more, it can go over that. Also, a fine of $1,000 or more may become a lien against the lot and collected through the lien foreclosure process if the authority to do so is in your declaration. Just for comparison, in a condominium context, condominium associations by law cannot file liens for fines. HOA, you can if it's $1,000 or more and your declaration authorizes lien process for an unpaid fine. What about a use right? The suspension of use rights to use the common areas facilities does not apply. Okay, you cannot suspend their right to use the common area to access the lot, utility service to the lot, or from having vehicular and pedestrian ingress and egress from the lot, and including the right to park. So those things cannot be suspended. A suspension applies to a member, and if appropriate, the member's tenants, guests, or invitees, even if the violation resulting in suspension arose from less than all of multiple lots if that owner owns more than one lot. Things to specially consider, okay? Notwithstanding anything in your document to the contrary, you may not levy a fine for the following. These are new things in the law that you cannot fine or suspend for, okay, or fine for. Leaving garbage receptacles at the curb or at the end of the driveway within 24 hours before or after the designated collection day or time. Leaving holiday decorations or lights on a structure or other improvement longer than indicated in the governing documents, unless the decoration or lights are left up for longer than 1 week after the association provides written notice of the violation. Use right suspensions for failing to pay. So we talked about suspension and fining for non-monetary violations. What about monetary? In other words, failing to pay. You can suspend an owner's right to use the common area facilities if the owner is more than 90 days delinquent in any monetary obligations. That would be an assessment, fee, fine, due the association. And this could be adopted by or approved by board action. You don't need a committee meeting for this. You do for the others. For the suspension to take effect, written notice of the suspension must be mailed, delivered, or emailed to the owner, and if applicable, to the occupant, licensee, or invitee of the owner's lot. Suspension of the right to use the common areas and facilities does not apply again to common areas used to access the parcel, utility services, and you can't prohibit the owner from having vehicular and pedestrian ingress and egress to their lot or the right to park. Also, these suspensions must be approved at duly noticed board meetings, okay? The board can do it, but it has to be at a duly noticed board meeting. A suspension applies to a member and when appropriate, their tenant, guests, or invitees, even if it only arose from one of the lots that owner may own. And it ends upon full payment of the delinquency. By the way, suspensions, difficult to enforce in my experience, because it's not like the police aren't going to enforce it. You can't just drag them out of the pool by the hair. Maybe you could deactivate a fob or something like that for access to certain facilities. But the suspension of use rights, you can make them go through the guest gate rather than the owner gate. Sometimes that's pretty annoying for the owner. If you have a gated community, but on a whole, they're not the easiest things in my experience just to enforce the use right suspensions. What about a voting suspension? You can also suspend an owner's voting rights if they're more than 90 days delinquent. Again, at a board meeting through board action. However, the right to suspend someone's voting rights came into effect in the law in 2000, I believe in 2011. Okay. If you have documents before that time and there's no Kaufman language, then by the certain case that was decided fairly recently, since voting is a substantive, right, vested right, that cannot be suspended for these older associations unless their documents expressly allow suspension of voting rights or it has Kaufman language, where that law has been incorporated into those older documents, before July 1, 2011. So just be aware of that for a voting rights suspension. Again, for that to take effect, you have to give written notice, mailed, hand delivered, or emailed. Again, with the written consent of the owner to email. And if applicable to an occupant, licensee, or invitee of the lot, it applies to the member and when appropriate, their tenants, although they're not going to be voting anyway, even if delinquency results from more than one lot, from less than all the lots. And interestingly, importantly, if you do suspend someone's voting interest or are delinquent, you jump through all the hoops, with a proper board meeting notice and then the notice to the owner, the voting interest suspended is not counted toward the total number of voting interests for any purpose, and including the number necessary to establish a quorum or required to approve an action, including elections. So it's like that lot doesn't exist, okay, for voting purposes if their voting rights have been suspended for the time period of the suspension. And again, it ends upon when they pay. Mandatory pre-suit mediation. This is the process that most associations will follow if they're going to sue someone, quite frankly, for a violation of the covenants. You go through this mandatory pre-suit mediation before you go to court. So how does all this work? Okay, this is under 720.311 of the HOA Act, by the way. Okay, use of or changes to the parcel or to the common area. Okay, these are topics that are covered or issues that are covered by pre-suit mediation. Change to the parcel, the common area, amendments to the documents, meetings of the board, membership meetings, not including elections. We talked about elections before. They have a different process. Access to the official records and covenant enforcement. Those are subject to pre-suit mediation. What's not subject to pre-suit mediation? Collection of any kind of financial obligation. So collection of assessments. You don't go through pre-suit mediation. You just go right to court. Any action to enforce a prior mediation agreement or settlement agreement. Eviction or removal of an occupant or a tenant from a parcel. That doesn't go through pre-suit mediation. Alleged breach of fiduciary duty by a director or directors, and recall in election disputes. They go to the division. The recall an election. So before you're able to file suit, the aggrieved party, let's say it's the association, you want someone to do something, architectural control violation, let's say, okay, that they put in something, wasn't approved, you properly disapproved it. Basically, before you can sue them about that architectural violation, you first must send them a demand for pre-suit mediation. That form of that demand must comply with section 723.11. It has the letter or the form of the letter right in the statute. So you just basically follow the statutory form. It has to be sent by certified mail, return receipt requested, and by regular mail to the last address of the responding party that appears in the official records. The demand to participate in pre-suit mediation must include a list of the 5 certified mediators, or a list of 5 certified mediators. Then the responding party, in this case the owner, they must respond within 20 days by agreeing to the mediation and selecting at least one of the mediators. The mediation must be scheduled at a mutually convenient date and time and take place within 90 days of the date of the written demand, unless extended by the parties in writing. The parties are required to share the cost of the pre-suit mediation, split equally, unless they agree otherwise. Okay. The mediator's fee. The mediator may require advance payment. Those proceedings are privileged and confidential, just like a court-ordered mediation. People who are not parties to the dispute cannot attend, except the attorneys. And if you have a quorum or more of the board members in attendance, that's not a board meeting. Okay. It's not a board meeting, doesn't require notice. So if a quorum or more of the board attends the mediation, again, you haven't triggered a board meeting requirement. Although typically the board will designate one of them as the authorized contact for the mediation. You either mediate and come to a resolution or of the dispute with a mediated settlement agreement, or an impasse is declared. How is an impasse? Well, an impasse happens if you have the mediation and the parties don't agree to any settlement. It's an impasse. It's also an impasse if any party fails to respond to the demand or response. Any party fails to agree upon a mediator, or any party fails to make a payment of the fees and costs within the time established by the mediator. Any party fails to appear at the mediation without the approval of the mediator, or the mediation cannot be scheduled and conducted within 90 days after the demand was filed, unless both parties agree to an extension. So if there is an impasse for any of these reasons, then the moving party can file suit. Okay. If it's settled, then it's settled, and there's a mediation agreement that's entered into at the mediation. Attorney's fees are awarded, by the way, only if pursuant to statute or contract. So contrary to some belief, every lawsuit doesn't end up in the prevailing party getting their fees. It has to be pursuant to a statute or a contract. In the event the person who fails or refuses to participate in the pre-suit mediation process prevails, then they're not allowed to recover their fees. So let's say that the person that you're moving against doesn't respond to the mediation, doesn't show up to the mediation, just ignores it, and then you sue them. And if they happen to win, okay, they've waived their right to recover their fees because they did not participate in the pre-suit mediation process. If a dispute is not resolved at pre-suit mediation, then the prevailing party in any subsequent arbitration or litigation is entitled to seek recovery of all costs and fees incurred in the pre-suit mediation process. Okay, assuming that the parties did both participate, the prevailing party is entitled to get their fees if it goes further into litigation. If a dispute was settled at pre-suit mediation, but an action seeking enforcement of the mediation is sought, in other words, you settle it, you have a mediation agreement, but then they violate the mediation settlement agreement. The suit to enforce the agreement, the prevailing party is also entitled to seek recovery of their fees in that instance as well. Your declaration may provide that if there's a violation, you have a self-help remedy. In other words, you can go on the property and cure it or fix it. If you have that, then in recent case law, you must attempt to exercise the self-help remedy before you can start the litigation process. Because an injunction, which is typically what you're looking for, to enjoin someone from doing something or to compel someone to do something through an injunctive order, that's an equitable remedy. But if you have a remedy at law, which is to go on the property and cure it, you have to try that remedy first before you can do the equitable remedy. Again, check your documents. If you do have a self-help right in there to remedy the problem. Doesn't mean if the owner stands on their lot with a gun and says, get off my land, you force them, you get into a confrontation. But if you do have a self-help remedy, you have to exercise or try to exercise that first before you can pursue litigation. I have reached the end.
You did it
And
with
what, 4 minutes to spare?
4 minutes to spare, which means you can
Oh, no,
do.
he went long. Actually, I went long, didn't I? So, but
No, you did well, folks.
Patty, thank you, everyone.